Well, I'm praying for listing this matter on Monday, my lord.
Pardon?
My lord, praying for listing this matter on Monday.
What matter?
Suspension matter, my lord, he's under suspension, my lord, since last 6 months, my lord.
Okay.
May I please, your lordship, praying for listing a repetition on filing. Well, we have filed started, lordship. Matter is regarding the compassionate appointment at 2, lordship, and
Today.
today. Tomorrow then, lordship.
Okay.
Okay. 15 and lordship, 15 September is last date for application.
Okay.
Tomorrow, lordship.
No, tomorrow not possible. Lot of matters have been.
Right.
May I please, your lordship, may I pray for listing of a matter on Monday, my lord, regarding compassionate appointments? Hello.
Meet your lordship. When I'm praying for listing of this content matters on Monday, my lord, the urgency is this, my lord, the matters were listed on 29/8/25 on last occasion, my lord. My lord, I'm deeply obliged.
I have also same prayer, my lord, for witness.
I also same prayer, my lord, either Monday or Wednesday, my lord.
Witness.
Well, I cannot 34 and 35. No question.
How many matters are there?
2 matters.
Well, so far, item number 34 and 35, my lord. This matter perhaps instructions I have to take instruction, my lord. So matter may come up after vacation, my lord.
Item number?
35 and 34, 34, 35. I'm bound for the petition, my lord.
Is Lord at Council for the petitioner.
After vacation.
He may be granted 1 week time.
Maybe, my lord. 34, 35.
They will inform the other side.
Yes, yes, my lord. Sheikh Mukhtar is there, my lord.
This is a matter of.
After vacation.
Okay. It's matter of. You will lock. Then we may dispose of.
My lord. And 21st. 21st, 18 September.
18.
My lord, instead of my Wednesday, can you do Friday next, my lord? This content,
Okay.
next Friday, deeply obliged.
May I please, your lordship? Lordship, item number 21. We will file an additional affidavit, and it has sent to vetting, my lord. So, one week may be granted.
You will inform the other side.
Yes, we have taken the consent of other side.
Mr. You serve not Lord. The name council for the respondent. In Secretary Education Department. Concept from the others. Let's call this.
After a week, my lord.
After a week. So we are link to file and additional.
Additional affidavit, yes.
Wherever.
Lordship, praying for listing a 2 matter, one is pension and one is provincialization matter. So it's be possible 19/9. First. Order mention. Order mention. Admission. Lordship, one, there is WPC 434 is very urgency matter, Lordship. If possible, then 19.
How it is are.
19 before puja.
Yeah, please, your lordship. I want to list a matter relating to admission matters, my lord, on 18, my lord.
After we, my lord, I'd like to mention in respect of item number 10, your lord, sir. My lord, the matter may be passed over for a week, your lord.
And by Mr. Rohan, Lord's after a week.
My lord. Master bless.
With the consent of the petition, I to item number 31. That will be taken up after vacation.
Yes, learn
Petition. So I am for the petition.
it.
I am for the petition and also in 31.
So and then. As for listing the matter after petition.
After vacation, not. So can you fix a date after vacation? We have to be. Let it be last week of October. Lots. Obliged.
Next list, Lordship, item number 43, petitioner file an additional affidavit. The same may be called close.
Item number
43,
43. Put that
I am for the,
in the matter.
Lordship, in this case, Lordship, we filed additional affidavit that too may be called for in item 43, Lordship.
Okay.
Lordship, in item number 29, my lord, we are going to file affidavit in opposition today, my lord.
Lordship, I am for the petitioner. Lordship. There is an urgency, my lord,
29.
possible next week, my lord, regarding my selection and appointment. 29 and 30,
Okay.
and next week, Lordship.
Made by Mr. Sophia and Bernard Snapper, company for the element. Having been objected by Mr. Gogoi, Bernard Board of Put the matter is adjourned to be listed after a week.
Lordship, that may be fixed, my lord, because this is my lord, selection and appointment, my lord, in the part of completion of the my lord, selection. So there is no, my lord, before vacation, my lord, there is urgency. My lord, process is my lord, in the part of completion, Lordship, therefore my lord, urgency is there. Lordship. 24. Lordship. Deep Lordship.
Prepare for listing up to admission matters as per your lordship's convenience.
After vacation, you can take any.
My lord, the same prayer, my lord, before vacation, my lord, petitioner is my lord retired, but
Not possible.
Yes, Mr. Lordship. Lordship, I beg to mention for listing of a writ petition. Lordship, it is the family pension benefit, Lordship. Pensionary benefit, Lordship. And moreover, she is a lady of 70 years. So Lordship kindly,
In the
admit-
mission column,
yes, Lordship.
immediately after reopening,
Lordship kindly before vacation because it was supposed to be listed on,
we have fixed lot of matters before vacation.
Lordship, like it was listed on 13th of May. And it was supposed to be listed of 29th of May, but then it has not been listed till date. So Lordship kindly.
Not possible.
Obliged, Lordship.
wait, Elizabeth, my lord, one part at matter, my lord, the matter was lastly listed on 8/4, my lord, 2025, my lord. And order is there to list the matter after, immediately after due vacation. But I pursued the office, but the office told that lordship is taking up some other matters, not civil matter, therefore. And they told me to make the.
After vacation, we will try.
After that,
Before vacation, not possible.
let me then.
Well, we have got the relief in this case.
But Mr. Yagdo. He has the instruction to withdraw this petition. As the related. Sought to in this petition has been granted by the respondent of her plea. Accordingly, taking of the substance. Garden. This is substance closed.
Obliged, deeply. Meet with your lordship. Lordship, the engaged counsel, Miss P. Bora, she is on leave, lordship, due to bereavement. Her father-in-law has expired 3 days ago, lordship. Kindly pass over the matter for today and fix the matter immediately after vacation, lordship. US Bora.
Immediately after.
Most obliged.
Lordship, non-compliance of order dated 10/4/25, my lord. Page 19 is the operative part. Paragraph 22. The aforesaid exercise has to be carried out within a period of 2 months from the date of receipt of the certified copy of this. The petitioner shall obtain a certified copy of this and place the same before the respondent authorities within a period of 1 week. Thereafter, my lord, petitioner submitted his representation 22/4 before the respondents, my lord, and 23 Lordship, 29/4/2023, 25 mile. There are 3 respondents. Page 18, my lordship issued the mandamus, my paragraph 18. Under the fact and circumstances by a mandamus of this court, the respondent authorities are directed to release both area and current salaries of the petition.
Third, Mr.
Jail Australia.
Prosper, learned. So number 11 and 12 of the chapter. Related Article 215 of the Constitution. Yeah, is prepared by the applicant to non-compliance. The order dated that for 2025, on the court in WBC number 660/2023. Where is the petition and the documents license record and also part of the document and order dated also order dated that for 2024. WBC number 660/2023. Obviously, it's up to the respondent and progress. Step be taken by registered books, daily and almost the usual process. List of current or it's
Obliged.
May please also. The contempt petition, my lord, your lordship order dated 25/3/2025, operative portion page 39, para 12. Your lordship order, my lord. Page 39, my lord, para 12, under the given section.
Mr. Akora, or this petition under section 12 of the protect. Dated Article 215 of the section of India, it's prepared by the petition of willful and deliberate violation of the order dated 25. Passed by this court in WBC number 868. Where is the so the document record where the order dated 25/2025. Topic fee put to the responsibility return or it's the big taken by with alien with list of for this.
Much less.
Matter relates to compensation appointment lawsuit. Petitioner challenge the OM lawsuit, 2024 OM lawsuit. In the meantime, lawsuit, DLC considered my case and forwarded to SLC lawsuit. In the pending of the case lawsuit.
Yes, madam.
Lordship, the matter may be disposed of lordship as a one-time major lordship. And sent for SLC plus preparation.
Or Mr. L. Gogoi, Garnet Council for Document. More Garnet nothing of the part. This petition Article 6 of the concept. That's right voice direction to the purpose. So that's the your matter was earlier placed before the DLC.
Lawsuit,
Then DLC has rejected your
lawsuit. Thereafter, High Court passed an order to place face DLC
therefore it's placed before the DLC.
No,
lawsuit. Already in the meantime, lawsuit, pending of the case, DLC already considered my case, Lordship.
If the DLC has approved your pair,
Lordship.
so why the pair is to place the matter again before DLC, it will go to SLT?
After filing of the case, the DLC recommended, Lordship.
After filing.
First DLC recommended.
Of this, after filing of this case,
Yes, Lordship.
then you file one additional affidavit pending on records.
So, जो करबो कारण.
Does it close the matter? It is partially infarct us, Lordship.
But
This is infarct us, Lordship. Already
Yes,
DLC
Lordship.
recommended. My pair was also recommended to SLC, Lordship. For case consideration. By DLC. DLC already considered, Lordship.
you record the resolution of the DLC.
Suppose.
And because of this, by directing the respondent to the matter before the SLC. Otherwise, you will not place the matter. Again,
Yes.
you have to acknowledge review.
এইটো DLC already হৈ গৈছে.
I'll file additional affidavits
By next Monday,
next meeting.
then the government has also issued one notice
Yes, sir.
inviting application. Are you aware of the schedule?
Plus, I know.
Yes.
Within 15 days, directed to submit the.
For the 15th of
Let's start with the learner.
September.
Submits that. During the pendency of this petition, the petitioner was DLC. The DLC has approved the schedule. Then he submits that in the 1 week time to file an additional reading of record. The DLC. Resolution of the DLC. There is record to be allowed. Is the matter of next Tuesday.
Publish. 16. Publish.
May I please, your lordship, I'm appearing on behalf of Lanit Council SB Chaudhary lordship. She is on next in court number 6. Matter may be taken up at 2 PM lordship.
Well, after some time, madam, not at 2, madam. After some time, madam.
I mean, she has she has several matters in court number 6, similar matters. That's why she requested that 2 will be comfortable. for-
Typical thing.
At 2 কোন লোক হবে, মামা?
At 2 PM lordship.
But madam, second half, madam, I may not be available, madam.
Anyone can appear lordship.
Madam.
At 2 PM lordship. DPO.
May I brief? In this case, I am praying for similar order, my lord. It is given at page number 74 to 82 is the operative provision. 80, my lord, with regard to the BAD increment, similar order. It was passed on 21 and compliance order at page number 83 was given recently, my lord, 16/8/2025. So I'm praying for similar order.
How many petitioners are?
Worship,
How many petitioners are?
my lord, here only 9 petitioners.
Mostly. So, Torma, you have checked the order? You have
My
gone
lord.
to the order?
My lord, here, this order is based on the on writ petition number 6241/2015 and order dated 16/2/2016. My lord, in this writ petition, after conclusion of this writ petition, my lord, there was an writ appeal. And in the writ appeal, Honorable Division Bench was held that we accordingly closed the appeal as infructuous. However, the question of law involved in the proceedings are kept open and nothing prevents the state authorities to take necessary actions as regards the grant of increment to B.Ed degree holders as per rules without any way affecting the benefits in respect of 41 teachers. Then my lord, 41 teachers are those who were writ petitioners. And thereafter in 12, it is made clear that since the appeal pertains to aforesaid 41 graduate teachers, this other is confined to the aforesaid, this order is confined to the aforesaid 41 teachers only. And thereafter, my lord, one letter was issued by the director, and here it is stated that regarding the advance increment for acquiring B.Ed degree. With reference to the subject cited above, I have honor to state that in pursuance to Honorable Court Order dated 16/2016 in writ petition so and so, assistant teacher of provincialized secondary schools were considered to get one advance increment for acquiring B.Ed degree, provided that such teachers fulfill the eligibility criteria by issuing the office letter number so and so dated 21/7/2016. You were requested not to act upon this office letter number so and so dated 21/7/2016 until further order. This is the judgment here, my lord. Our division bench held it.
They have, my lord, acted upon at the page number 83, they have acted upon, my lord,
So, my lord, in this matter, my lord, motion may be, notice of motion may be issued. In the meantime, we will file our affidavit also here.
So now, you have been directed to examine the matter of whether this case of the case of the petitioners are covered by the order dated 16/9/21 or not.
My lord, although it is covered, my lord, that the order was passed on 16/9/2021, but in the readable, the order was passed on 12/5/2022, my lord.
may I please, lordship? Let me clarify this, my lord.
But this order was speaking order was passed on 16/8/2020.
2025.
Because of one of the writ petitioner,
After passing of the judgment in this writ appeal.
yes. As because, my lord, in compliance of that order, my lord, one of the petitioners, Jatin Kumar Borua was there, and so this order is passed by the inspector of school. So Jatin Kumar Borua was there.
Verify the record. And pass the same speaking order.
My lord, let the motion, notice of motion may be issued here, my lord.
Why to do it?
Because
If the case is covered.
here, my lord, the petitioner in WPC 4005/2021, and my lord, order was passed 16/9/2021 with a direction to give them the incremental benefit of B.Ed degree. Accordingly, in compliance of that order, my lord, the inspector of school has given the benefit to the petitioner, Jatin Kumar Borua. But my lord, here he is coming just now after getting the order, and in the meantime, my lord, the division bench has passed that order, my lord.
Oh, after
And-
passing of that order, this compliance.
And my lord, moreover, this notification has already been withdrawn. You were requested to not to act upon the office letter number GBEST BAED increment 1/2016/14. Yes,
These petitioners have acquired their B.Ed degree prior to T7/2012.
yes, madam. But under that notification, my lord. My lord, in 21/7/2016 notification is there, my lord. I have given that.
Let me see
So
the-
here it is, my lord.
see the difference.
Yes, I have given. First one is notification, my lord.
2022.
Yes, my lord.
And this compliance order was also in the year, last few days, right?
In respect of my lord, that writ petition, my lord.
Yes.
Writ petition number 4005/2021, my lord. Here it is mentioned here. My lord, third paragraph. Whereas no action was taken by the competent authority regarding their claim and being deprived of the some petitioner of the case bearing case number writ petition 4005/2021 had filed the contempt petition at the Honorable Guwahati High Court bearing number contempt 403/2022. Regarding this, the Director Secondary Education Assam had issued a letter to the undersigned by letter number so and so dated 13/3/2025 for compliance of the court order passed in WBC 4005/2021. Regarding only, my lord, death case, not other case, my lord.
Can you make a classification of that point? Respect of the petition.
My lord, they are, my lord,
One
newly
person
coming and
is-
they are,
or one person is then one benefit. Similarly situated person also entitled to the same.
but
So
my
they are
lord,
not petitioner in that direction.
they have filed the contempt petition and in compliance that contempt petition, my lord, that order was issued. So here it is mentioned.
So
But my
therefore
lord,
they are not entitled.
my lord, let the notice of motion may be issued, my lord. We will file our
Yes,
affidavit,
you
my
will-
lord, here.
You will take time year after year to file your affidavit, and the case will be pending here.
After vacation, my lord.
Let them verify, my lord, and if we are entitled, the authority will give, my lord, otherwise not. That's
Now, in the matter we are discussing.
This order was passed by the inspector of school regarding the compliance of the contempt petition, my lord. In respect of WPC 4005/2021, my lord.
And
But
therefore
division
their
bench is
case
clear,
not
my lord.
covered by this order. Is it your submission?
My lord, let the matter come after vacation, my lord.
Yes, what is your submission?
yes, Lordship will, Lordship will dispose it of after recording his submission, my lord.
Pardon, sir, pardon. Pardon. Uh, pardon. Verdict. Yeah. It's have right to it's direct respondent with no participant. Or B. To grant the benefit of one advance increment account of procurement of B and degree. And to all similar order. As has been passed in WPC number 4005. Professor learned that the petitioner presented arguments assistant research. Postgraduate research is different high, but high. They were appointed prior to 2012. Before the amendment of the Assam Secretary the service of and they have obtained their BA degree and therefore they are entitled to an advanced increment on account of the said BA degree. As the same has not been granted to the petitioners. They have jointly approached this court by praying for similar direction. As has been passed by this court in WPC number 455 of 2021. I ordered it is sought drawing the attention of its court to Annexure 6B at page 83 of the books that after the order being passed by this court dated 16/9/2021 in W for 455 of 2020, the respondent authorities have extended the benefit of advance increment to one Pratik Kumar Borua, graduate research, who was the petitioner in WPC number 455. And the circumstances, sir, Professor has consented to extend the similar benefit to the present petitioners. The other hand, sir, you Sharma learned counsel nothing of some extent that the system notice my and as after the order passed by this court in WPC number 4005 of 2020, the state has deferred on a date WP number 366 and the thing was disposed of by the order dated 12/5. On the ground of being practical. And as such, of and thereafter, the director of secondary education, the letter on 21st of August 2018, requesting the inspector of schools not to act upon the office letter number ZB S SD stroke at implement stroke 1 stroke 21 2016 stroke 41 dated 1 until further. But having heard the conversation started of both the parties, I have carefully gone to the such record. Order dated 16/9/2021 passed by this court in WP number 4,500 and the speak order dated 16/8/2025 passed by the inspector of its MT Albert and also the order the division and public order dated 12/5 of the letter of the narrator. Dated 20 of August. Sanjeev Sharma, Learned Counsel, Standing Counsel, Respondent Authorities have not disputed that the present petitioners are also covered by the order being passed by this court dated 16/9/2021. And a perusal of the aforementioned order and also the contents and also considering the contents of being made in this court is of the view that the each of the petitioners are covered by the order dated 16/9/2021. And it also appears that the state order has been complied with by the inspector of the school authority. By order dated 16/8/2025 in respect of one of the petitioner named in the court. The present petitioners are also entitled to consider under the given text and circumstances, this court is inclined to the school jurisdiction by directing the respondent authority to verify the case of the present petitioner. In the light of the direction given by this court in the order dated 16/9/2021, and if they are found eligible, then the said benefit by the extended them. And the aforementioned exercise has been carried out within a period of 3 months from the date of receipt of certificate.
Pleasure.
Shall obtain a certificate of this order, plus the same before the 1 week from today.
Back to lordship, my lord. My lord, I just want to clarify it, my lord. First, this matter was listed before Honorable Justice Nelson Silo, my lord. Because for some difficulty, his lordship directed this matter to be listed before the another bench, my lord. And that is why I am before your lordship now. What happened in this case is, my lord, my father was a student of number 881 Gorishankar Hindi LP School, Gauripur, Dhobri Mile. Subsequently, that school was amalgamated under the new style and name Mohanlal Subhasariya Hindi Academy ME School, PB College Road, Gauripur. So, my lord, then, my lord, I appeared for the SSSB, CRPF, and other exams of this under central government, my lord. And subsequently, I qualified, my lord. I have also qualified for the physical efficiency test, which is PAT, and also for the physical standard test, PST. And my lord, for getting an appointment, I have to submit the PRC for the job purpose, my lord. I applied in the before the school, and the school replied that prior to 1981, all documents are not with them. Now I just want to take your lordships to Annexure 1, page 14. Annexure 1, page 14. I'm just reading out the only relevant portion for your lordship's kind convenience, my lord. Sri Ramasa is my father, my lord. Serial number 1, Sri Ramasa, son of so-and-so, had studied in 881 number Gorishankar Hindi LP School, as then that was existed. His study was finished in the school on 31st December 1973. He was passed class 3, means common, my lord. From the school, his age was 11 years, 5 months and 11 days as on 31st December 1973. Your lordship is very well aware that during those days period of 1960s, 1970s, 1980s, until 1986, the date of birth while delivering the school certificate as reflected in Annexure 1, the student's date of birth is not mentioned. During those periods, lordship is very well aware of that. Now, my lord, the original is on, my lord, page 15. Annexure 1, page 15, my lord. This is the certificate of my father. It is also subtle, my lord. Now, my lord, PRC for domicile is not issued to anyone. So there is a government notification of 2012, my lord. I do not need any domicile, my lord. That is already stopped, my lord. I appreciate the government's this notification. I only need PRC for the job purpose, my lord. The which was refused to me, my lord. I have made different RTI applications before the concerned authorities. Only that nobody has given me this. So that is the difficulty I'm passing now. I've qualified 4 exams, my lord. And also, my lord, I just want to draw your lordship's kind attention to Annexure 2.
Who is applying for elementary education?
I'm applying.
But the certificate was not issued.
Yeah,
No, not here, say the pair, if he the pair person.
kind of school certificate.
Yes.
And if any notice may be issued because the exercise will be done by the headmaster, madam. We cannot appear on behalf of the headmaster.
Can you apply an instruct?
My lord, my appointment letter is supposed to be issued to me, my lord, and then on verification, if it is not shown, I will not get any job, my lord. And in this regard, my lord, I just want to place one of the very charismatic judgment of the Honorable Supreme Court, my lord.
Not necessarily right.
My lord,
So without hearing the head.
my lord, my lord, my lord, absolutely, my lord.
Heard expresses from a product
Assessor Rahman.
and also heard
And
that for product.
120, madam.
District direction to the. That's one and perfect. Issue. Certificate of the petitioner's father. That notice being submitted. Weeks. State upon respondent number 4 with indicate by registered with baby and also by the process. However, no for notice is regarding the respondent number 1. Entered evidence and but extra requisite of the parties who are this after 2 weeks. The 6 certificates informs the permitted after taking charge of the petitioner certified on affidavit reporting score. After 2 weeks.
Madam.
Highly obliged, my lord. Obliged, my lord.
May I plead the lordship?
Yes.
My lordship, the petitioner has appointed as a lecturer in English department of Suntil Ansali College on
19/2/2002. The petitioner, after being permitted by the college authority, has registered himself for the pursuing the PhD degree at Mogot University. Thereafter, obtained the PhD degree, the petitioner service was provincialized as an assistant professor in the Sontur Anjali College, which the petitioner rendering his service. Respondent number 2 served showcase notice dated 26/6/2020. Your Honor, it is the annexed in the petitioner in the petition page number 30, Your Honor. Thereafter, the petitioner submitted his reply on 4/7/2020 by denying the charge level against him. After 1.5 years, respondent served notice that 03/12/2022 requiring him to attend at hearing, and the petitioner attend the hearing on 8/12/2022. After the hearing 8/12/2022, the respondent authorities were sitting idle and did not take any the action to conclude the disciplinary proceeding against the petitioner. Unfortunately, my lordship, the respondent served another showcase notice upon the petitioner on 01/6/2024. Respondent served the notice with view to harass the petitioner, Your Honor. Mentioned that the first showcase notice served 26/6/2020, and after about the 4 years, the another showcase notice has served on 01/6/2024, Your Honor. The humble submission before Your Honor court, please set aside the showcase notice, and I have the similar case, Your Honor, order in my hand. I can produce the order. Your Honor, notice may be issued.
Lordship has already issued similar cases. Lordship.
No.
Pardon, sir. Yes, your name, please.
G. Hussain.
Your name. Our looks are auditor, but it's nothing of our appearance of this type of passing. I think it's like the departmental proceeding is they take it by 26. And also set aside that was the second so-called notice dated 1/6/2024 by the court. The verdict of the petition that the was is serving as which college you were serving?
Sontali Anjali College.
Petition is serving Suntali Anjali College in the Department of
English.
English. The Department of Health lecturer. And lecturer. He enrolled himself for PhD program at Mobile University. And he obtained the degree on 2014. Thereafter, the service of the petitioner was provincialized as assistant professor by order dated 2015. Thereafter, the petitioner was served support notice on 26/6/2020 by the respondent number 2. On the ground that the petitioner has split the authority with regard to his PhD. The petitioner then submitted his reply on 4/7/2020 and denied the charges level against him. Then thereafter, departmental proceeding was drawn up against him at later dated 3/12/2020. And thereafter, he appeared for the inquiry of 3/12. And in spite of completion of the departmental inquiry, the respondent authorities have not taken the said inquiry to its logical conclusion. Instead, on 1/6/2024, the second support notice was served upon him with the number of charges. And being aggrieved, the petitioner approached this court. Then notice be issued to the respondent returnable and for step be taken by the exert of Canadian by the process. Okay. Then the matter after for it in the maintain. Mr. Auditors have obtained necessary instruction with respect to the of the departmental proceeding of Ronald Subsistence by support notice dated 26. And also by support notice dated 26/6/2020. Please stop here for
May I, Your Honor, yeah, similar matter, Your Honor, 14, similar matter listed in the 14, Your Honor.
Item number 14 is same.
Same matter.
Same.
Yeah.
Department key,
Department, education, some, Your Honor.
English college.
Oh, department, no. Yes. Philosophy, Your Honor, philosophy. Oh, yeah, Your Honor,
at the time.
showcase that is chance, Your Honor. Showcase, two showcase, one show.
Will check it
Oh.
up. In which college you are serving?
Halafura College, Dhubri.
Today.
Dhubri, Halafura College,
Item number 14.
40.
Apply that.
My lordship, made the matter taken up to some time.
Let it be. Next week, my lord.
Next week.
Next week, my lord, let it be. No urgency in it, my lord. They're telling advertisement in connection with the seniority list, seniority there. They're claiming seniority against the private respondent. Let it be. Monday, my lord.
Agreed by
Wednesday.
agreed by learned advocate of the court.
This matter, my lord, petitioner earlier being graduate, my lord, they were appointed in a my lord, ME school, my lord, in intermediate scale of pay. And subsequently, my lord, on 1/6/2006, the school has been amalgamated with the my lord, higher secondary. And
thereafter, my lord, they obtained my lord, the BA degree and master's degree also. And other my lord, similarly situated persons are now my lord, receiving the great pay of rupees 8,700. But petitioners are still receiving my lord, 6,800. The case is that, my lord. So, my lord, here in 6 pay commission, my lord, the the grade pay of graduate trains teachers, my lord, grade pay was fixed at rupees 2,300. And thereafter, my lord, several objections were came, and then one anomaly committee has been constituted. Anomaly committee has, my lord, given a report suggesting the grade pay of rupees 2,700. Lordship will find at page 47, my lord, of my petition. Seven. The grade pay for this is the notification issued by the my lord, Principal Secretary Finance Department. Notification dated 19 February 2011. Relevant portion page 48, my lord. Lordship will find 2,700. Revised to my lord, 2,700. And thereafter, my lord, Lordship will come to annexure 10, my lord, at page 49. My lord. Subsequently, my lord, one case was filed before this honorable court. Then, my lord, some persons who were not graduate at the time of their appointment, and their grade pay was stopped. And again, they were allowed to receive the grade pay of rupees 6,800. And thereafter, my lord, on the basis of that order, the department, my lord, issued a notice to stop the, my lord, grade pay all over the state, my lord. Subsequently, the different petitions has been filed, and my lord, that order has been kept in abeyance. Now, my lord, the graduate trained teachers working in the amalgamated higher secondary school are receiving the grade pay of rupees 8,700. So, lordship, the notice may go at this stage.
Your only pair is to grant great pay.
Yes, my lord.
Where the question of regularization arises.
No, my lord, regularization, question of regularization, no, to fixing the grade pay at, my lord, regularize the grade pay, my lord.
Or Bobita Garnet. Or prevent things of the address by the petition that they are serving. As they were initially appointed as assistant teacher to extra copy of MPs. The intermediate is developed. And subsequently, they were transferred to Margua, MIs, which was subsequently amalgamated with Margua and Margua HS school on 1/6/2006. Thereafter, the petitioner obtained their graduate.
Post-graduation.
BA degree. And despite being graduate, trained teacher and amalgamated in provincialized higher school, they have not been granted the grade pay at the rate of rupees 8,700. As for notification, the finance department related to the as provided by ROP And petitioners have also filed their representative that the same way to get being effective. Approved by file. Where is the representation?
Representation lordship will find at page 84, my lord. Annexure 21.
Yes, madam, you dispose of this related or not of this representation?
That the notice नहीं दो.
Have heard of submission. Learn it for both the parties provided that not return. Storage. However, equal to. We have to both the however, the set of the parties party. The matter of the matter is just furnished. Something for the related part. File the academic.
Deeply obliged.
Obliged.
May I please, lordship? My lord, this is my lord relating to my lord non-payment of my lord medical reimbursement, my lord. My lord, the petitioner is my lord family pension holder, my lord. He is wife of ex-lecturer, my lord. That is page 14, my lord. Thereafter, my lord, my lord, admitted into hospital for her treatment, my lord. And after getting treatment, my lord, she submitted representation, my lord, for my lord, granting reimbursement, medical reimbursement, my lord, but till that nothing has been done, my lord. There is a notification, my lord, that is an exact 3, my lord. In terms of the notification, my lord, I am entitled the medical reimbursement.
Notice may go, I'm going for 1 and 2, higher education department. And other parties are also there, finance and health is also there.
Other parties that
Finance and health. And moreover, sit,
will pay the amount.
not sit,
Will pay the higher education department will pay.
higher education
madam.
will pay, not sit, but it will have to come from all the medical bills, etc. will have to be forwarded from the health. And not it, my friend has pointed out one notification of at page 15, whereby said that reimbursement is entitled to the pensioner. But however, subject to let's say the second page, some documents will be required. Those are not furnished here or placed here next here. Those are the lordship may come to page 16. The next notification. So they at paragraph 2, they will have the petitioner have to furnish these documents to the health department first. Then they will forward lordship. That 2 clause 1 authorized medical attendance recommendation. 2 clause 2 recommendation of the referral medical board where applicable. So whether referral.
Yes, whether you have filed this document.
My lord, all documents we have submitted before the my lord, my higher education directorate, my lord. My lord, kindly see page, my lord, 15, my lord, and my lord, representation on the representation, my lord, kindly see 15. Sorry, my lord, page 31. September 2024, my lord. Immediately after my lord recovery of my treatment, my lord. Including the documents my lord, I have finished with the petition, my lord.
But here
and the medical board referral certificate, my lord, that is obtained by the higher education department itself, my lord, but not by us, my lord.
No, that is not. There is a medical board in the GMCH lordship. They just, they look into the disease or the patient. Thereafter, if required, refers. As per my knowledge, lordship. And health department will be the best person to lordship. Apprise the honorable court about that. So let the notice may go issue the lordship.
Or Mr. Hussain, or that- the public card, or being just
1 and 2 lordship.
three,
I am 1 and 2 lord.
one and one and it's follow up or respondent number three. Anybody for AG? Directorate of Health Service,
That is health department, health service and health. 5 and 6 health. lordship.
the grievance, the petition. Right. The wife of late Dura Nalik, who was the ex-lecturer of the Disciplinary. And she has been sitting family in the right video number 9067. He would be WD 5948 after the date of her birth. She was suffering from different pain and undertook treatment at Israel Hospital. With effect from 4-5 4 and therefore that us Pakistan treatment from 95 and she has also undergone treatment at 9 years of her specific and at the hospital like 7 and her expenses incurred expenses amounting to 12,9,089. There he has submitted representative of all the medical will be for payment of for medical reimbursement of the aforesaid, but the same paid open at this month. Further sub part of the party provided that not on state of the respondent or who by the ticket by registered agent of the one of format notice is required to the test or one the participant but extra set copy of the participant to submit it for weeks.
My lord, in the meantime, my lord, there shall be no bar on the part of the respondent to consider that.
It's clarified that vacancy of the petition will not be a bar for the for reversing the procedure.
May I please, Your Lordship? My Lord, the petitioner was put, my Lord, under suspension, my Lord. But before that, my Lord, on 3/5/2024, my Lord, he was issued the show cause notice. Then, my Lord, on 3/6/2024, he replied. Then, my Lord, 8/9/8/2024, my Lord, page 31, he was put under suspension. After, my Lord, the proceeding was initiated, my Lord, he had submitted his reply, my Lord, saying, my Lord, that last part 2 paragraphs, my Lord. In view of the above, for pending drawal of disciplinary proceedings, Sri Deepak Bodle so-and-so is hereby put under suspension under the provisions of Assam Services Disciplinary Appeal Rules 1964. Well, my first submission is that this, since this was already was put under the discipline proceeding has already been initiated. The show cause, the charge sheet was issued. Well, there ought to be a reason order for a suspension. That is not there. It doesn't indicate any reason why a suspension is necessary. Secondly, my lord, Lordship will find thereafter his suspension has been extended from time to time. Lordship will see page 34 is the next order.
Page?
34. 35, 30 minutes. 34 is the order mill. Sorry, 34 million is representation. Sorry, 34 is representation. 36 million. 36. Now, this was on 28th of November, 2024. His suspension was extended from 10/11/2024 to 10/2/2025. This is within 90 days period. Then, the next order is at page 7. Now, his suspension is in terms of this 90 days expired in terms of page 36 on 10/2025. Now, this was done on 13th of March 2025, after more than a month. His earlier suspension period of 90 days expired on 10/2025. Now, this was extended by an order at 13th March 2025 with effect from 10/11/2025 to 11/5/2025. Got it, madam? Then, page 38. This is an order of 8th August 2025.
The first exception order was which is time.
In time, madam.
And the second one.
Second one not in time, madam. Then, third one and fourth one have been issued simultaneously with
The first exception was it post from 10/11/2024 to 10/2025.
5, madam.
Then the review ought to have been done before 10/2/2020.
Exactly, madam.
And they did it on
13th of March. Yes, madam. Then, next extension, Lordship will see on 8th August it was done. And the period is 11/5/2025 to 11/8/2025. So just before 3 days, when this subsequent period was supposed to end, that was done from 11/8. On 8th of August 2025. This is almost 5 months afterwards. 13th of March 2025. Then next is 8th of August 2025. 5 months, madam. Almost. That to a prior period, 11/5/2025 to 11/8/2025. Now, within
the say breaks on
Hold on.
10th of February 2025.
Lordship, as far as the department is concerned, my lord, if your lordship, very rightly, the petitioner council has pointed out my lord, that the first one was done correctly. The second one was done himself, my lord, has been done, my lord, on 13th of March 25. No doubt there is a, my lord, rightly or wrongly, my lord, has been done on 13th March 25. But my lord, March 25, my lord. Now he's come now, my
You
lord.
justify it how it is rightly done.
Well, rightly or wrongly, my lord, if whether what the petitioner's counsel has said that there has been a delay, no matter, within 3 months it should have been reviewed. But my lord, my contention as far as the 13 March 25 is concerned, though rightly or wrongly, that's what I'm saying, my lord, rightly or wrongly, if this order is wrong also because it has been passed later, not on time, they should have been diligent enough to come on time, my lord, before the court, my lord. 13th of March, if this was done, they should have come in at that point of time itself. Now it's my lord, month of my lord, September. Looking into that aspect, my lord, lordship will issue notice today, my lord. Let me file a consolidated, my lord, affidavit, my lord. Because of the fact that, my lord, he's rightly or wrongly, my lord, this order, rightly or wrongly, my lord. But my lord will see that aspect also, that the petitioner.
Except you produce the relevant file.
My lord, we'll do it.
Examine it.
Yes.
Lordship.
Yes.
And my lord, that may be done, my lord. But one thing, my lord, the petitioner also should have been diligent enough to come on time. If 13th of March a wrong order had been passed, rightly or wrongly, my lord, he should have been diligent enough to come on time, my lord. He has come in the month of September. This is a motion matter, my lord. So that all aspect also your lordship should look into it. That my lord coming late, my lord, and my lord, because the allegations also has to be looked into, my lord.
No. Can we deny the benefit to him only because of his delay?
Delay, my lord. Absolutely, my lord.
How?
My lord,
Where it is provided?
my lord, that way it's not provided, my lord, it's the discretion of the court, my lord. That's why I'm saying, my lord, that's why I'm saying, my lord, regarding 6-2, my lord, and the other thing, my lord, that, that part,
The last extension order is 11th of August 2025, my lord. Even that is also, my lord, in violation, my lord. The last extension order is 11th of August. I've shown one order of 8th of August, my lord, then another 11th of August, my lord.
well, I'll leave it to lord. 1, 2, 3, my lord. 1, 2, and 3.
The order of suspension with 9/8/4.
9/8/24, my lord, is order. Initial order of suspension. Page 31.
So, Lord, the was senior assistant of the chief of Oregon. And he was under suspension with effect from 9/8/24. And prior to passing of the suspension order, that's also not. The further summits that the order. Suspension order was being extended from time to time without any application of fine. And after expiry of the period of time. And in the month of August 2025, period were extended by periods. In a space of 3 days. Taking the but I have heard the article the part that return for which step be taken by research how the extra check of the next return file before this court original file before
Lakshmi will have it after the vacation, well. After vacation. Deeply approach.
This method relates to compassionate appointment, my lord. My mother died in the year 2016. Initially, my case was placed before the DLC on 2/11/2017. That was not considered because of lack of vacancies. Thereafter, I approached this honorable court, page 32. Yes, ma'am. Then page 33, on the instruction of the government advocate, stated that my case will be placed before the next DLC. Thereafter, my case has not been placed. I have submitted all the documents as per this honorable court. And matter is pending before the DLC, my lord. In the meantime, the office memorandum has come and the notice also issued. The last date is on Monday, my lord. And therefore, I pay your lordship to dispose of the matter, my lord, allowing us to submit the particulars.
Oh, where is the bar in submitting that particulars?
Well, because there is an provision, my lord, page 53, then page 54, clause number 11. I have to submit the certified copy of the honorable court order, otherwise they will not accept.
Clause number?
Clause number 11, page 54. This is the type copy, 55 is the original copy.
Yes, madam.
Lordship, kindly turn to page number 34, Lordship. Again, the district elementary education officer, the district board is directed to place the case before the of the petitioner before the for his appointment under the dying harness before the DLC, Lordship. But we do not know whether the case was of the petitioner was placed or not. So, Lordship, I think it is better to obtain instruction from the DO the after court order why it is not placed. If not placed, then why not placed? But before that, Lordship, I think. No, DLC pressure online hold.
Yes, sir. Therefore, I have approached my lord. My case has not been placed, therefore I have.
Lordship, Lordship pass an order to place the before the DSA, Lordship, but directly not before the authority, Lordship.
That is my case, my lord, to place the case. My lord.
Before that, we have need to obtain instruction why it is not placed before the DLC, Lordship.
When the instruction will be available?
By Monday, Lordship.
Monday is the last day, my lord.
আজি তো সম্ভৱে নহব না
Then tomorrow, my lord, will possible.
আমি সব কাম আগে
Or at 2 p.m., my lord, they will obtain instruction over telephone.
Tomorrow.
Tomorrow.
বন্ধ আছে না কালি
tomorrow, Lordship.
Heard Mr. and Sharma learning from the production. What is your name?
In the Okalatnama, my name has been reflected. My lord. Okalatnama, I have signed the Okalatnama.
That's for
I'm for government, Lordship.
In the winter is for. It also the public assessment from the district elementary education officer. That's why the case of the petitioner was not placed to the district level committee. Person from the direction issued by this court. In WPC number 686/2022 by order dated 6/12/2020. Next tomorrow.
My name may be reflected, my lord, in the cause list. My name has been.
Will you go and file
Yes, ma'am.
file an application before the rest?
Yes.
May it please the Lordship, matter relates completion at upon my Lordship. DLC, in this case, Lordship, DLC recommended the petitioner, Lordship. Page 33, Lordship.
Already tried to recommend for the same.
Start from page 32, Lordship. Relevant page 33, serial number 8, Lordship. Thereafter, Lordship.
23.
Yeah, madam. Or have you
Yes,
filed the petition?
Lordship, dispose of the matter with a direction to place before the authority, Lordship. So, this one is a lovely name. అలాగే DLC అలాగే ఎఫర్ట్ చూస్తాయి కదా
Heard Mr. and outside Lord. And also heard more Lord subject also products.
I'm for government, Lordship. I'm for government, Lordship. 1, 2, 3, and 6.
Or government certificate for the respondent number 1
1, 2, 3, and 6, Lordship.
and 6. And for other subject group of
4, 5. 4 and 5, Lordship.
1 and 2.
I'm appearing for 1 and 2, Lordship. 1, 2, 3, and 6.
5. the events like sought to be addressed in this petition, Article 226 of the Constitution. PI the father of the petitioner led Forest thus was certain head teacher of the now with the MU. The district petition officer document the district of the then he died in harness on 2002. Fast before coming into post of the notification dated 1/4/2017. And thereafter the petitioner will apply for being appointed on compassionate ground, but the same failed to evoke any response. And being aggrieved, the petitioner approached this court by filing WBC number 4451 of 2021 for issuing direction to the respondent authorities for consideration of this case for being appointed under compassionate ground. Thereafter, pursuant to letter of the Joint Secretary to the Dr. Bansa, Department of School Education, indicating that action will be taken on withdrawal of the writ petition, and subsequently the same writ petition was withdrawn by the petition. And thereafter, the district level committee has considered the case of the petitioner on 1/9/2023 and recommended him for being appointed on compassionate ground to the post of UP teachers. Thereafter, the case of the petitioner was forwarded by the district commissioner Lakhimpur to the commissioner and secretary of some department of school education for placing the same before the SLC. But the same has not been placed before the SLC by the respondent authority. And in the meantime, the Dr. Basam Personnel P Department issued office memorandum dated A.104/2024/19 dated 18/24. Resolving not to place any case for appointed on compassionate ground before any DLC or SL. So, since further submits that the petitioner was recommended by the DLC Lakhimpur on 1/9/2023, was earlier than the issuance of OF dated 18/9/2024. And subsequently, the government will issue one notice dated 38/8/2025 inviting application from the candidates. Where is that notice?
Yes, 44, Lordship.
And under such circumstances, Mr. Saint contented to issue direction to the respondent authority to place the matter of the petitioner before the SLC. Is more learned counsel for the respondent and also Mr. Begu finds that there is no objection. In the event of disposing of his petition by directing the respondent authority to place the matter before the concerned SLC. Taking note of the submission, having heard the submission of learned counsel for both the parties. I have gone to the petition of the documents placed. To heard the recommendation of the DLC dated 1/9/20. Office dated 38/5 like 38/8/2020. The substance of burden of the party this court is trying to dispose of this petition by directing the respondent over to as the each of the petitioner before the next SLC. And the effort on exercise has to be carried out with the receipt of
Obliged, Lord. Right, please, your Lord. This is similar item 16, Lordship, only date of DLC is different, Lord. Page 33, Lordship, serial number 6.
Yes, it's a David.
Lordship, page 33.
Similar order.
Lordship, but only one addition to be made, your Lordship. The authority will do. In doing so, that in that clause 4, the parameters, the criteria that will be looked into, your Lordship, which speaks about that immediacy.
This is separate order.
Not separate, your Lordship. So it's my submission that
Whether
that
it was issued along with the notice.
yes, on 30th August 2025.
This is not the part of that. It's different. You decide his method
Yes.
in accordance with.
Yeah.
Okay, we'll pass the order.
Obliged, sir.
Yes, Mr. Gora, the information is available with.
Yes, my lord. Thanks. My lord, why this notification dated 13/3/2024? The schedule 3 of the earlier rule has been substituted, my lord. An earlier rule, my lord, as your lordship indicated, as page 63 of the affidavit, my lord, where there was a requirement that DME shall constitute a medical board consisting of not less than 3 head of orthopedic departments, my lord. It was of the year 2017, my lord, and at that point of time, only locomotor disability was allowed to, the reservation for locomotor disability was allowed, my lord. So, my lord, that time there was, therefore, there was requirement of 3 orthopedic, but subsequently other disabilities have been also allowed, my lord, under the rule. And therefore, neurology, ophthalmology, everything has been included as per the board. And this has been constituted in terms of the, my lord, the information bulletin that I have produced before your lordship, my lord. It is the information bulletin for National Eligibility Cum Entrance Test UG NET UG 2025, my lord, based on which, my lord, the present admission process is going on, my lord. So the relevant portion, my lord, your lordship will find as page 34, my lord. I have tag marked it, my lord. Page 34 is the relevant portion. It deals with, my lord, the persons with disability and persons with benchmark disability, PWD and PWBD. The clause 6.3, my lord. 6.3. Provisions relating to persons with disability, persons with benchmark disability. So, my lord, the first portion is regarding their examination procedure, appearance in the examination, my lord. The time, what extra time has to be given to the persons with disability in the entrance test. And the relevant portion, your lordship will find that page 34, my lord. It starts, and relevant portion 6.5, my lord. Clause 6.5, page 39, my lord. 39. Your lordship has page 39.
Yes.
So 6.5, it deals with the guidelines for PW persons with benchmark disabilities candidate for admission purpose, my lord. So the present scenario, my lord, is dealt with by this clause, my lord. 6.5, then if clause C, my lord. Candidates who consider themselves eligible for this category are advised to ensure their eligibility by getting themselves examined at any government medical college, district hospital, government hospital. Such government medical college, district hospital, government hospital shall issue a disability certificate in reference to Chapter 7 of the Rights of Persons with Disability Rules 2017. Means, my lord, the disability certificate that the petitioner has produced before for appearing in the entrance examination issued by the district authority. So such a disability certificate is issued as per the Schedule to the Rights of Persons with Disabilities Act 2016 and the guidelines for the purpose of assessing the extent of specified disability in a person included under the Rights of Persons with Disability Act 2016, notified in the Gazette of India by the Ministry of Social Justice and Empowerment, Department of Empowerment of Persons with Disabilities, Divyanjan, on 4th January 2018. And it is important, my lord, does not confer any right on any candidate to seek a admission in a medical course under PWBD quota. So that certificate doesn't confer any right on a candidate to get admission, my lord. It is important. The aforesaid certificate shall be to ascertain whether candidate can apply to NTA, National Testing Agency, my lord, for appearing in NET UG 2025 under the PWBD quota. So that certificate is only for the purpose of qualifying to appear in the entrance examination only, my lord. So then, my lord, clause D. Then what is next? Thereafter, the candidates, upon selection under the PWBD category, shall have to produce a disability certificate issued by the Disability Assessment Board, which shall have assessed the candidate in reference to criteria prescribed under the Regulation on Graduate Medical Education 1997 as amended up to 13/5/2019. Thus, it is relevant that the candidates, after declaration of the result, have to appear before the Disability Assessment Board. In the instant case also, that board has been constituted, my lord. Board so as to determine whether they may register or participate in the common online counseling towards admission to medical courses. In case candidates are found to be ineligible by the Disability Assessment Board in reference to criteria prescribed under the regulations of Graduate Medical Education 97 as amended on 45/2019, they may not register or participate in the common online counseling, and any online provisional allotment of the medical college shall be entirely fraudulent on the part of the candidate. It is relevant that physical verification of various certificates, including academic as well as disability certificate, is only upon reporting for admission to the medical college. Then clause E. It is further clarified that the certificates issued by the authorized centers designated for the purpose by DDA shall only be considered for admission into the medical courses. And no other certificate issued by any other government medical college, district hospital, government hospital will be accepted. So in this case, the certificate that has been issued by the duly constituted board, only that will be accepted, my lord. No any other certificate. Then, my lord, the clause G, my lord, likewise, the designated counseling authorities of state, union territory governments shall constitute disability assessment boards, centers for assessing the suitability of the candidate in reference to the criteria prescribed under the regulations on graduate medical education as amended from time to time, and shall notify the same on their respective website. So in terms of this provision, my lord, that board has been constituted, as your lordship will find at page 64, my lord. Page 64, that board has been constituted, and my lord, the assessment has been done by that board, my lord, wherein the petitioner has been found to have disability of 15% only, my lord.
Whether this information bulletin
Yes, my lord.
is incorporated in the amended rule of 2024.
No, information bulletin is published every year, my lord, for the purpose, because it is the information bulletin of 2025, my lord. And if your lordship comes to page 11, my lord, page 11 of this bulletin, my lord. So what the 1.1 says, my lord, the national eligibility cum entrance test is being conducted by NTA, National Testing Agency, since 2019 for admission to the undergraduate medical education, with the approval of the Ministry of Health and Family Welfare by OMOM. The Ministry of Education, Government of India, has established the National Testing Agency as an independent, autonomous, and self-sustained premier testing organization under the Society Registration Act for conducting efficient, transparent, and international standardized tests in order to assess the competency of candidates for admission to premier higher education institutions, with a mission to improve equity and equality in education by developing and administering research-based, valid, reliable, efficient, transparent, fair, and international level assessment. Then page 13, page 13, clause 2.3.2, my lord. Page 13, my lord. 2.3.2, the information contained in this information bulletin relating to the pattern of exam, syllabus, eligibility criteria for appearing in NET UG, the quota of seats, reservation, PWBD, persons with benchmark disability, person with disability, admission norms, procedure pertaining to the concerned courses are as per the norms set out by the respective regulatory body. So every year, my lord, this information bulletin is published in respect of the test, my lord. And so in terms of this information bulletin, the terms and conditions contained in this information bulletin, my lord, the test and admission process are conducted, my lord.
That's all right, but my question remains unanswered.
Yes, my lord. Your lordship put the question there because as per the rule of 2017, my lord, there should be three orthopedic head of three orthopedic department, my lord. So that has been amended. That notification I have produced, my lord, 13/3/2024. That rule has been substituted, my lord. So that rule is not in force, my lord.
In which rule that the constitution of board has been dealt with?
The constitution of there, my lord, in this notification, it has not specified any mode or how it has to be constituted. But, my lord, the information bulletin that I have referred, my lord, 6.5.g, my lord, it stipulates that there should be assessment board. So normally, my lord, that whatever the disability, vision or hearing impairment,
whatever disability is there, my lord, stipulated in the rules, my lord. So in respect of all the disabilities, one specialist is there in the board, my lord, in that board, the HOD of each of the respective departments, my lord. Because the constitution of the board at page 64, my lord, if your lordship is 65, my lord. 64, sorry, my lord. 64, there is specialist from in every department, my lord, in respect of every specified disability, my lord. Psychiatry, orthopedics, neurology, ophthalmology, ENT.
Yes, is there any reply?
Yes. My whole argument was one. As per 24 rule, amended schedule, the 17 rule, as your lordship has already gone this through this rule. 17 rule was in July 17, and the guideline for assessment it is came up in sometime in 18, my lord. The guideline came up on by 4th January 18. After publication of guideline, the rule came to be amended, and schedule 3 was substituted by amendment 24. State government has substituted the earlier. Earlier was there was a quantification of disability 45 to 70. In case there was some with some rider that 40 to 70. But now, as per amended rule and as per guideline, what is the percentage of a particular person applying under the quota? This is not a matter of concern. Whether it comes under expression specified disability, this has to be asserted. Whether it is specified disability. So that was my whole argument yesterday. So my humble submission was the medical board. So I have no any objection. I have no question about the my lord efficiency of those people who are in this board. I never raised. But the question is that when a judge, a judicial officer is to be selected, my lord, I may be allowed to explain this in a manner. Suppose in a
Required to explain it.
suppose my lord, a grade 3 post of a judicial officer is to be selected. Will a doctor or something other will come to select the my lord? Obviously, the expert in this field, my lord. I am an, my lord, locomotor disability. My disability had to be assessed by an expert. They are ophthalmology, they are neurologists, they are ENT.
Orthopedic is also there, my lord.
One person, one.
Yeah,
that is
but
my that was my content. This is not a board one.
This schedule
Yes.
where the requirement of the orthopedic.
The theory is not a question. Whether it is my humble submission, my entire argument was that whether it was as per the guideline published on 2018. The guideline, your lordship, for a moment, once again, kindly peruse the guideline. Is detailed criteria has been given. Your lordship, for a moment, kindly peruse this guideline. Once again, my lord, I'll pain your. I'm sorry to pain your lordship for my lord. Your lordship, kindly peruse the principle. How, my lord? What is how it is to be ascertained? Detail has been given, but the affidavit in reply, what says? Only it is written 15%. Nothing, my lord, no procedure followed. That was my whole contention.
So your guideline is at page number?
In my book, my lord, may not be the same book, my lord, my 116. After rule, guideline for the purpose of assessing only three point, your lordship, kindly peruse. Hand component, total value of hand component. the functional impairment of hand is then principle of evaluation, total value of prehension is 30%. So percentage is given. What is the percentage such and such, such and such? Nothing is there. এখন দিতে আপনি লাগলে এখন দিতে they had to put what is the percentage in that case. So all that things are there, detailed guideline mail. I have marked this point, my lord, relevant to my case. Nothing there. Only says 15%. So this is my submission. And the other day, my lord, yesterday I have already pointed out my very fundamental pleadings they have not denied in paragraph 4. That is not denied. And I am relying upon 3 judgments of the Honorable Supreme Court. I will not pain your lordship by reading the whole relevant. I will just supply your lordship, my lord. I have noted the relevant paragraph in the top of the judgment. So here in one case, Supreme Court has said quantification is not to be looked into. Barrier, what is the barrier of a particular person? That has to be taken into account. And barrier has been defined in the Act. What is the barrier? By virtue of his disability, what barrier a particular person has to face? That has to be looked into. That has taken into consideration. That was not done. So 3 judgment of Honorable Apex Court, my lord. I am just handing over the
Lord, in our affidavit, we have enclosed the report only. But the records are there of the board, my lord, where the assessment has been done in terms of the guidelines only, my lord. Assessment, the assessment of the disability, my lord. Everything has been done in terms of the guidelines. Here we have enclosed the report only, my lord.
In first case, my lord, that is Bikash Kumar case, relevant paragraph is 40, 43 and 44. On the top of the judgment, I have written the relevant paragraph I am relying upon.
So they. So that specific disability, they have constituted the board. And the board has found your disability to be 15%.
This is my submission, my lord. Percentage is not a matter. Whether I come under the expression.
Merely because one person is coming under the category of specified disability, whether all will be accommodated.
Yes.
The persons
Has
between 14.
subject to evaluate 3%. Then it will be that it will be depend on marks. Supposing 3 seats are reserved, money for disabled person, and 18% is found to be eligible for appointment for 3 posts, then merit will come, my lord.
My lord, that
is not a case in my case, my lord. Merit will come.
regarding
What is my marks in the NEET?
query of your lordship at page 32, my lord, that disability has been specified. Who are eligible for?
Okay.
Page 32, my lord. It is a notification. Yes, my lord.
32.
32 of the of my affidavit, my lord. It starts at page 31, my lord. These regulations may be called the Graduate Medical Education Regulations Amendment 2019. So relevant portion is page 32, my lord. So eligible for medical course, not eligible for PWD quota, less than 40% disability. And eligible for medical course, eligible for PWD quota, 14 to 80% disability. not eligible for medical courses more than 80%.
That
So
H,
that has
my
been
lord.
specified, my lord.
Notification and appendix H was put to challenge in one of my cases. Here Supreme Court has categorically said that H, appendix H, my friend is now referring, my lord. Supreme Court, a question of quantum of disability is not to be taken into consideration. Therefore, I am relying upon three judgments.
Yes, Laura, you please go through the judgment. Then. We will hear you after 2 o'clock.
Yes, sir.
Here two.
After 2. 6.
I am available.
My lord, copies of the judgment may be furnished to me so that I.
Court master will supply.
Yes, sir.
Court master will.
Lordship, this matter relates to compassionate abandonment, Lordship. Lordship, the DLC Lokhimpur at page 47, Lordship. Meeting dated 26/10/23, page 47. And my serial number 5, Diganto Vishwas. Serial number 5, Lordship. Placed as per letter number so-and-so, dated so-and-so, received from the Joint Secretary to Dr. Basu.
DLC has recommended your name.
Yes, Lordship. Due to this OM, Lordship, as well as this recent notice dated.
So there was a direction of this court.
Yes, Lordship.
Which one?
Lordship,
WC number 2780 or
This, the page 44.
626.
Yes, Lordship.
Which one?
Page 44, the communication by the Joint Secretary, page 44. This was issued by the Joint Secretary addressing to District Commissioner regarding page 44, regarding WPC number 3626. That is one. 2020 Diganto. This is my case, Lordship. In inviting reference so-and-so, I am directed to request you determine the sensitivity of the claim of the petitioner of WPC number 3626 Diganto Vishwas and so-and-so, and suggest the ways to bring a matter to a logical conclusion if candidates are deserving one by holding a DLC meeting. In doing so, you are requested to take into account the individual collective court cases filed these petitioners, and the action on your part will have to be taken only after the litigations are withdrawn by the petitioners. Pursuant to this order, my pending case was withdrawn, Lordship. Then my case was considered, Lordship, by the DLC Lokhimpur. And I have enclosed the similar order, Lordship, at page 63, Lordship. Recently, this order has been passed by the coordinated bench, Lordship, in WBC number 5130, page 63. In connection with some similarly situated person, Lordship. And I have also included the recent OM, Lordship.
Lordship, here this matter, your Lordship, on perusing the event, because these were matters which has some connections with regard to the fake DLC. Lordship, on perusal of the synopsis itself, your Lordship. So after that, on perusal of that, Joint Secretary Kagosto
44.
44. On perusal of that particular communication also, ways to bring the matter to a if the candidates are deserving ones by holding a DLC meeting. You're requested to take into the individual collective court cases filed by these petitions, and the actions on your part will have to be taken only after the litigations are withdrawn by the petitioners as any decisions on the.
Then I have withdrawn, Lordship. Page 45, 46, the withdrawal order, Lordship. Page 46, Lordship, on 8/9/23, Lordship.
So may I be allowed that what was the outcome of that? What was the outcome of that fake DLC related issue, your Lordship?
That is, Lordship, the
No,
fact.
that may not be applicable in the present case.
Yes.
Because there is one letter, the Joint Secretary, this is number 44. where the repetition number and the name of the petitioner has been reflected.
Yes, yes. Case 63 is similar.
In case number 47, at serial number 5, his name is there.
45 is the withdrawal order, Lordship. 45 is the withdrawal, Lordship. Pursuant to this office communication by the Joint Secretary, I have withdrawn this case, Lordship.
No, 47.
Yes, Lordship.
That is
Yes.
what I'm saying, Your Lordship. The DLC had very well placed that as per letter number 23/8/20 received from the Joint Secretary to the Department of and consequent upon withdrawal of the white order, it was decided to recommend for the post of
Yes.
LP. But Your Lordship, I'm submitting that with regard to the issue of that fake DLC list, Your Lordship, what they have found, Your Lordship. Because this particular batch of petitioners, since they were involved in that, what was the outcome of that? I'm not objecting that his claim, Your Lordship, but may I be allowed to what was the outcome of that, Your Lordship?
Lordship, it is there, record is there, Lordship. Lordship, initially the petitioner was appointed, Lordship, pursuant to DLC recommendation. And some person approached this honorable court claiming that some incumbents were appointed from a fake DLC, Lordship. In that DLC, my name is not there. There's the Lordship court directed those persons who are appointed fake DLC, their service could be terminated, Lordship. And there's petition order is also there, termination order. I was not there. When order was issued directing the commissioner to the direct limitation to terminate my service, I approached this honorable court, and this honorable court says that, Lordship, I was not the party and I was not from the fake list, Lordship. That is why my service was stayed. The stay order was operating, Lordship. In the meantime, government has decided, Lordship, directed since the issue is different. I was not a part of the fake party, but my record was DLC record was not available in the DC. That is why there is a discussion. You would do your case, will select you fresh, Lordship. The operating stay order is so there from, Lordship.
It took look court order, sir.
Yes, yes.
If the petitioner can show the honorable court's order with regard to that, then
Yes, Lordship. Page 24, page, Lordship. Sorry, Lordship. Page, that is page 39, Lordship.
39.
Page 39. My termination order, Lordship, which I challenge, Lordship. Lordship will find the 11th portion. Page 42, Lordship, 11th portion. Page 8, Lordship, para 8, Lordship. My petition. We have perused the list of 14 candidates included in the fake DLC recommendation dated 16/3/13, as well as name of the respondents in WPC number so and so, who are in the fake DLC, Lordship. The name of the petitioner Digushinto Vishwas appears neither in the list of 14 candidates in the fake DLC resolution, nor he included in the as respondent in WPC number 278/17 and other petitions. In the circumstances, we are of the privacy view that the reason given in the order dated, that is 14/6/20 termination order, to terminate the service of the petitioner would be inapplicable in the case of the petitioner. On a privacy case being made out and also considering the balance of convenience and irreparable loss that the petitioner may suffer, the effect of the decision to terminate the service of the petitioner Digautam Vishwas contained in the communication dated so and so by the Additional Secretary, Government of Assam, shall remain state until further order. This was operating in the meantime. They suggested by this letter, you would do this case, we will consider first. Then I have withdrawn with liberty, Lordship. This is my case. Now the issue has gone, Lordship. Now my DLC has recommended the SLC case will be placed, they will consider as per law.
Yes, Your Lordship.
Yes,
Yes, Your Lordship. Lordship,
the OM I have sent notice, Lordship.
626.
Page 67, that is 38. I have included last date is 15, Lordship. 15th of.
Yes. Yes, then because the page 44 has mentioned about the case number, then it can be. No. It's supposed to clear whole again. Not. Yes.
Yes.
Oblige, Your Lordship.
May it please, my lord. My lord, this is my second round of litigation, my lord. I've approached this honorable court for releasing of my subsistence allowance and my lord 4 KVPs, that is the Kishan Vikas Patra, my lord. My lord, on allegations of providing false counterfoils of payslip, my lord, I was terminated from my service. I was a employee of Guwahati University, my lord. I was working as a junior cash collector, my lord. Thereafter, my lord, this honorable court, my lord, would kindly have page 36, my lord, for a moment. I passed an order, my lord, directing the respondent authorities to release my subsistence allowance, my lord, prior to my termination and those 4 KVPs. My lord would kindly have page 37, the last portion, my lord. If I may read, my lord. In view of the said position, the writ petitioner is not entitled to receive the pension and pensionary benefits. However, considering the prayer made by the learned counsel for the petitioner, that the petitioner is entitled to certain other benefits, including the subsistence allowance and return of the said 4 KVPs, this writ petition is hereby disposed of by directing the petitioner to submit a detailed representation before the registrar, Guwahati University, highlighting the dues receivable by him other than the pension and pensionary benefits on account of the services rendered by him prior to his termination from service, including the claim for return of the 4 KVPs. My lord, as per this order, my lord, I had to submit one representation, my lord, before the registrar of the Guwahati University. My lord would kindly have the next page, my lord, page 39, my sir. My lord, this I had made, my lord, a representation I had submitted. Bottom portion, my lord, receiving is also there. But my lord, I think, my lord, because of some error on my part, my lord, petitioner's part, the certified copy was not annexed at that time. So we have preferred a fresh representation now, my lord. My lord would kindly have page 49, my lord. Page 49. My lord, requesting the respondent authorities to consider our prayer for the release of the said subsistence allowance prior to my termination and those 4 KVPs. Limited.
Subsistence allowance from who is that to?
My lord, prior to 3/5/2011. That is before my termination. From which period, my lord?
Yes.
Yes. My lord would have, my lord, it is for the period 6/4/2004 to 15/8/2006. That is there, and there are others also, my lord. Certain documents are with the respondent authorities. So, my lord, if an order is passed, my lord, we consider.
So subsistence allowance for this period 6/4/20
to 6/4/2004 to 15/8/2006. If my lord has annexure 4, my lord, page 29 for a moment, I will try to satisfy this honorable court regarding that.
page number?
29, my lord. 29.
Yes.
As per VC's approval dated 8/8/6, Sri Ram Gopal Prasad, Junior Cash Collector, Accounts Cadre, GU, he is under suspension with effect from 6/10/2003 with 50% of pay. His subsistence allowance is hereby allowed to draw 75% pay as subsistence allowance after 6 months of suspension period 6/4/2004. Now, my lord, I was placed under suspension on 6/10/2003, my lord. And my lord, for that period, my lord, for that 6/4/2004 to 15/8/2006, I am entitled to get the area of the 25% subsistence allowance, because initially it was 50%, then it was made 75%, but that 25% I didn't get for that almost 2 years, more than 2 years period. That is my case. In those 4 KVPs, those Kisan Vikas matter may be kindly disposed of, my, if it pleases my lord. May be allowed to file a fresh representation. Immediate prayer, madam. Court has also allowed previous.
So your submission is not clear from which that to which that you are entitled to 50% and thereafter 75%.
My lord,
Initially, my lord, my lord, now the law is that for after 2 or 3 months, it is 75%. Immediately after suspension, it is 50%. Then after that, it is 7.
Forget about the law now prevailing.
Yes, my lord.
During that time.
Yes, my lord. My lord, during that time, my lord.
For this order, annexure 4.
Yes, my lord. I am entitled for that 25% arrear subsistence, my lord. Because my lord, for that 6/4/2004 to 15/8/2006, I had only got, my lord, 50%. Yeah. The 25% area remains.
In which paragraph of your writ petition you have mentioned it?
Yes, ma'am. My lord would have paragraph 7, my lord, for a moment. Page 8. May I read, my lord? That after a period of 6 months from his date of suspension, that is from 6/4/2004, the petitioner was allowed to draw 75% pay as subsistence allowance, and in this regards, an order dated 16/8/2006 was passed by the registrar, Guwahati University, vide memo number so and so. But he was paid the subsistence allowance at the rate of 75% only from the date of the order, that is 16/8/2006, and the arrear subsistence allowance from 6/4/2004 to 15/8/2006 at the rate of 75% was not paid. During this period, the petitioner ought to have been paid 75%, but he was paid 50% only of the subsistence allowance. Therefore, the petitioner is entitled to get the arrear subsistence allowance at 25% for the aforesaid period.
Yes, Mr. Pupan, there was a direction of this court of why the order was not complied with.
My lord, I take your lordship straight to that order, my lord. Page 36, 37, 38, and it's on 9. My lord. Earlier order, my lord. My lord, page 38, my lord. 38 last 2 paragraphs, my lord. The said exercise shall be initiated and carried out within a period of 2 months from the date of receipt of the representation from the petitioner, along with a certified copy of this order. With the above direction, this petition stands disposed of. Now, my lord, if we come to the representation, my lord, page 50, 49 and 50, my lord. The relevant portion as page 50, my lord. Kindly note the date, my lord, page 49. It has been, my lord, submitted on 31/7/2025, and it was delivered, the last page, on 5/8/2025. That 2 months time period is not over as yet, my lord. The last page 53, down below, item delivered to Guwahati University 5/8/2025. So, my lord, possibly the entire representation is under consideration of the Guwahati University authority. So, my lord, little bit premature. In spite of that, my lord, notice may be issued.
Pay the amount and inform this court.
My lord.
Forget about the technicality. You are aware of the order.
Since, my lord, that within 2 months, it should be considered. So just 1 month, my lord, over. So possibly, my lord, that was considered, possibly, my lord. So I will have to obtain instruction in that regard.
Next.
At this stage, notice may go, my lord, and by this time I will obtain instruction, my lord.
Comply with the earlier order.
My lord.
Then you flex the compliance order before this goes on active.
My lord.
Heard, Mr.
Yes, sir.
Learned a topic for the and also heard the book product. The thing of the content about in person.
456, my lord.
subordinate bench of this court in WPC number 4593 of 2021. By order dated 10/1/2025.
2024, man.
10/1/2024. Has directed the respondent in Guwahati University
Page 38, Miller, second paragraph.
Registrar Guwahati University.
Second paragraph.
take a decision in connection with releasing the subsistence, arrears subsistence allowance at a rate of 25%. And also the 4 numbers of KPP. But the said order has not yet been complied with. Taking note of the submission of learned counsel for both the parties, it is provided that as the proposed learned counsel for the Guwahati University said, last before this court, the compliance report of the order dated 10/2024 on next date. Place the matter on. Further taking.
Miller. By this time, that 2 months period would be over, Miller. So, Miller,
I don't know, but you have to place the compliance order.
Miller. Miller, as per earlier order, the certificate copy has to be, Miller, furnished, but it was not furnished. Anyway, Miller, I will,
But
Miller,
that order
place the
was
compliance.
passed after hearing you all,
Miller,
so you are aware of the order.
Miller,
It is not that you are not aware of the order.
Miller,
You have to comply.
Miller. Most of like this.
Deeply obliged, my lord.
Please, your lordship. My lord, this matter relates to compassionate appointment, my lord. Here the petitioner's father, here the petitioner's father died on 16/6/1998, my lord. And he applied on 1/11/2005, and his case was recommended by the DLC, my lord, and the DLC recommendation is at page 59 of my additional affidavit. Additional affidavit. It's a 59. 59. Oh.
Serial number 10 is your
Yes, my lord.
name.
Name is Mobrul Islam Tapadar.
This resolution is updated.
Resolution is of dated 30/11/2023.
Since then, it was not placed before the SLC.
It was not placed before the SLC. In spite
When
of
you have approached this court,
my lord, we have approached earlier 2025, my lord, because after my lord this DLC recommendation, there was an official my office memorandum dated 89/2024, my lord, and because of that, it was not placed before the DLC, my lord. But subsequently, this office memorandum was challenged by a series of writ petitions, my lord, and subsequently there was a common order And by the common order, my lord, there was a direction for consideration of the my lord, cases of the petitioners of those series of cases, my lord. And since petitioner's case is similarly situated, my lord, and there is a recommendation of the DLC also, only my prayer is to
You
place
have, you
before
have
the
not approached this court
Yeah. No.
earlier?
Earlier, no, my lord.
And Lordship, earlier no application also filed. Lordship, kindly go to the page number 59. Yes, column Lordship, 1, 2, 3, 4th column Lordship. Last paragraph. Earlier
Earlier it was not placed, so there was a direction of this honorable
the
court.
DO Lordship, dated 29/11/20, the application was not placed earlier before the DLC Lordship. The DOE reported that no application was found available on record. And also added that the applicant has submitted proposal along with requisite records pertaining to the applicant to the family disease relative. By report that the applicant had submitted the application with the prescribed period after 1 year.
Madam, anyway, now the DLC has recommended her name, his name.
Not recommended, Lordship. Kindly.
Recommended, my lord, your
The
lordship.
DMC has decided to recommend the applicant for appointment on compassionate ground, and the report of the DO reveals that there is no vacancy admissible for appointment in compassionate ground as per the prescribed quota of commensurate to the qualification of the applicant in the establishment of the DO Karimganj, and adopts that the principle as prescribed at para 15 of the government OM number so dated Iman, and there is an admissible post in the establishment of the DO Karimganj in the category of assistant teacher and UP level schools and XRA as per the prescribed quota of 5%. The applicant is also eligible as per his qualification for consideration appointment in the aforesaid category of the post as stated in the meeting by the DO Karimganj, and accordingly the applicant has been recommended for appointment as 80 in
UP
level in the establishment of DO, and DO Karimganj has been requested to obtain the approval of the SLC. And
Recommended.
Recommended Lordship in 50, clause 15 Lordship, any other department Lordship, in grade 3 Lordship. As because he is not eligible for the assistant teacher Lordship, that's the qualification.
My lord, any post as per qualification. So this is the criteria of compassionate appointment, my lord. And since is recommended, my lord, only his place is to be placed before the SLC, my lord. SLC may decide, my lord, whether she is eligible or not.
But Lordship, as per now, recent notification Lordship, he has not challenged that OM Lordship.
Yes, we have challenged it.
18/9 Lordship.
Where is that notification?
We have challenged it, my lord. OM is page 30, 31, my lord. OM impugned OM is 43, 44. And earlier also we have approached this honorable court. I have annexed the order also.
This is Lordship now.
At 18th of September 2024.
Yes.
This is part of the
No, Lordship, now recently, Lordship, the government has, Lordship, this notice has been issued, Lordship. Those cases, candidates who has challenged the notification, Lordship, 18/9 Lordship.
And here we have challenged it. Challenge
Now,
is there.
Lordship, on that day, Lordship.
After also, my lord, it is clearly given that in the cases, in the group cases, as well as similarly situated cases. In, my lord, in terms of that order, my lord. We are covered, my lord.
earlier you have filed a
Yes, my
What
lord.
is the number?
Earlier, my lord, in 23 we have filed, and after filing this writ petition, there was an order of this honorable court to place before the DLC. And accordingly, the DLC is
What is
placed.
that order?
That is at page 29, my lord.
Yes, madam, there is one order of this court.
So my
Page
prayer is
number
very
29.
limited.
Page number 28.
28, 29.
Or as we should be learned from the or did you not? Or state this one. So all the respondent?
No, Lordship. I am for. Reference number one,
One, two,
1, 2, and 3.
anybody appearing for school education?
And 6, sir. 1, 2, 3, and 4. 4 and 5. 4 and 5.
4 and 5.
4 and 5.
And 6.
6 I am in Lordship. 6 I am here.
That's the recommendation of the DLC. Before the SLC. DLC dated 38/11/2020 and challenge the web dated 18/9/2020. Please submit. The father of the petitioner led Abdul Adnan was working as a investor in the government commitment number Uttarakhand LP school in the district of Barakas, and he died on 8. And after the death of his father, the petition after the beginning of the point 111/5. But its case not left for the state level committee that prepared under the law. Therefore, the petition has approached the score by 5 517 of 2020. And this court by order dated 4/10/2020 as to the court as the date for the next available DLC for district court. And accordingly, the case of the petition was asked for the DLC. The DLC are right. Right. Corinthians in its meeting held on 38/11/2023 that recommended the case of the petitioner for being appointed competent ground in any other department. But the state respondent have not placed this matter before the state level scrutiny committee. And being active, the petitioner approached this court by filing the filing and further submits that a coordinate bench of court state order dated 4/25 in WBC Court 4/25 has directed that all application for completion and appointment submitted by the petitioner be considered and disposed of by the concerned PLC SLC by taking into consideration the various guidelines prior to 1/4/2017. Laid down by the state government for completion and appointment that is done in the Supreme Court and the High Court. And the case of the present petitioner is also covered by the decision. And therefore, it is contented to dispose of this petition. The recommendation of the DLC respect of the petitioner before the is formal or not the DLC dated 38/11/2023 Subsistence. The petitioner has no qualification for being appointed as assistant teacher in the school. And therefore, he is not recommended for being appointed in any other department. And earlier, the petitioner has not challenged the OM dated 18/9/2024 and he filed his petition only on 17th of May 2020. Telling her the submission burden for the party for the and also for the recommendation of the associate by the PLC dated 30th dated 30th. Then it appears that the PLC has recommended the name of the petitioner for being appointed in grade in any other department in the district. And under such circumstances to allow this dispose of this petition by directing the response as the page of the as the recommendation of the DLC dated so before the SLC for the next event SLC. In parts of above is this was the part is the here. Certificate copy of the and the same voter the corporate
Okay.
My lord, I have gone through the judgments, my lord. It is in respect of a different context, my lord. In the petitioners, appellants in those petitions, my lord, they are above the benchmark disability, above 40%. In one of the case, he was 58%, and in one of the case, he is 44%. But still, they were declared non-eligible for admission, my lord, due to certain other terms and conditions, my lord. So that is a different context. Here, the petitioner is below the benchmark disability, my lord. In those cases, they were above the benchmark disability. If your lordship takes up the Omkar Ramchandra bond, my lord, 2024, that's the
Which one?
my lord, the 2024 SC 928, Omkar Ramchandra Gond, my lord.
So according to you, these case laws are not applicable?
Not applicable, my lord. Here, the petitioner is below the benchmark. So quantification is not an issue here. But in those cases, my lord, in all the cases, one case is not related to medical admission. My lord, two cases, my lord, Anmol, one is Anmol and one is Omkar Ramchandra Gond. In both the cases, both the petitioners are above the benchmark disability of 40%, my lord. In one case, in Anmol case, my lord, he is 58%. He is a disabled. He has the disability in hands, speech, etc., my lord, 58%. And as per the notification, my lord, at page 32, there is a clause, my lord, that although the petitioner are within the benchmark disability of 48, 80%, 40 to 80%, but both hands they should be both hands intact with intact sensations. So in that case, in the case of Anmol, although he was within the limit of benchmark disability, 58%, within 40 to 80%, but his hands were not intact, my lord. So that's why he was not allowed admission, my lord. He was declared ineligible by the assessment board, my lord.
What is the decision of the court?
Court then my lord, court constituted another board, my lord, and ultimately a board was constituted by the specialist from AIMS, my lord, and on the basis of their report, my lord, he was allowed admission because he was within the benchmark disability, my lord, 40 to 80%, as per the rules, but not beyond the rules, my lord. The other case is also similar, my lord.
So here the contention of the petitioner is that you were not supposed to look into the percentage of disability.
No, that disability percentage has to be followed because only the persons with the benchmark disability, benchmark disability, my lord, that terms is there, my lord. We hold that quantified disability per se will not disentitle a candidate with benchmark disability from being considered for admission to educational institution. So, my lord, the very first condition is that the candidate has to be within the benchmark disability of 40 to 80%. Then only, my lord, the other consideration comes. In those cases, both the petitioners are within that. Yes, my lord.
The case of the petitioner is that what the board has to look into is the specified disability.
Yes.
If he falls in that category, then
Yes.
his case
No,
is
my lord, after assessment of because my lord, in paragraph because in that case, my lord, the court has held that, my lord, under the information brochure, candidates with disability have to submit a disability certificate issued for the year 2024, the first certificate for appearing in the NET examination, and have to undergo medical examination at the disability assessment board. So these are the two conditions. First, they have to apply in terms of a disability certificate, and after being selected, my lord, they have to undergo the medical examination at the disability assessment board. So if the disability assessment board,
requirement is provided in where it is provided. The rule of 2024.
no, the information brochure.
No, sorry.
Yes, my lord. And this judgment has also relied on that brochure, my lord. If your lordship takes up the case of Omkar Ramchandra Gaur, the paragraph 5, my lord. Paragraph 5, my lord. The appellant appeared in the NET held on 5/5/2024 and qualified the entrance examination. The schedule for centralized admission process round 1 counseling for admission was notified on so and so. The appellant applied for the centralized admission process and claimed reservation under the OBC and the PWD category. In the provisional merit list published on so and so, the name of the appellant figured at so and so. Under the information brochure, I have also referred to the information brochure. Candidates with disability have to submit a disability certificate issued for the year 2024 and have to undergo medical examination at the disability assessment board. So this is the requirement.
Which was the order?
Yes, madam.
My lord, I just want to point out only one from the judgment, my lord. The lordship kindly take the judgment of Anmol. Anmol. Paragraph 20. A very important express, my lord, has been made by the Honorable Supreme Court. Page 20. As would be clear from the above, flexibility in answering individual needs and requirement is an essential component of reasonable accommodation. There cannot be this is important, one size fits all. So everything, my lord, in my understanding, each and every case has to be treated especially, but they cannot generalize. And in the first disabled assessment board are not, here a quotation, paragraph 19, autonomous to just look at the quantified benchmark disability as set out by the certificate disability cast aside candidate. Such approach would be antithetical to Article 14 and 21.
That's all right, but if your disability is below 50%, then
Certificate, my submission, just once again, I am summing up my submission in 30 seconds.
And what is the facts of that Anmol, my lord? He was 58%. And he was within the benchmark disability. Still, he was not granted admission, my lord. That was the issue, my lord. The issue is totally different, my lord. Totally different, my lord.
Law laid down. This is, my lord, study sizes is applicable on this court. What is the fact? That is not applicable. What is the study size? Supreme Court has said quantification cannot be the sole ground. Number one. Here, my case is that first, my condition not, it is an admitted fact. They have admitted it, not denied. Next, in their case, they have taken plea that lower abdomen, that was their another plea, lower abdomen. The lower limb,
That is not the.
upper limb was not as per 17 rule. Today, my friend has made U-turn and says it is. In the first date, my argument was that a 24 rule has been amended. So all these things have not been done as per guideline, my lord. I have supplied my book. There is guideline is there, my lord. Your lordship kindly go through this judgment. I will take it later, my lord. So as per guideline, what is the guideline? What should reflect in the report of the expert? That is not. So my alternative submission was there to reassess. So it is my second submission. My first one is to.
No, so Sase directs.
What is,
from
if my lord,
the
if.
finding of the board.
Yes, my lord.
board
For
may-
that purpose, he has to challenge.
No,
the
there
report,
is.
my lord.
So
Your lordship
that
has
is one of my argument, my lord. That was not a board. It was a single man.
No single man.
Cannot be treated as.
It's a
Because
board.
a board must be expert of particular field, at least two, more than one.
That rule
That is my argument, your lordship.
Rule has been
It is your lordship. Your lordship may accept or reject. That is up to your lordship. But that my condition, your lordship kindly record this submission. That's my humble submission. Because one man of my lord cannot constitute an expert panel, man.
If it is not relevant, you cannot demand that I should record it in my judgment.
What, that is in everywhere, three judgment I have, my lord, relied upon. Where all are board. 3% in one case, 5% in two cases.
Here the board is of about 5%.
No, they all are expert in different field, my lord. Five categories of disabilities has been, my lord, notified. All are expert in different field. I would like.
In fact, my lord, this judgment will support our case, my lord. Oblige, my lord.
Here, I have filed this application for implement of Secretary, my lord, Education Department, SS on number 2.
Yes, who is appearing for elementary education department? Bora, you are allotted to deal with this matter?
No, my lord. This contempt matter, my lord, and the Khatonia is there, my lord. My lord, item number 18, my lord. Well, I can appear on behalf of Khatonia, my lord. The implement, no, well, I have no objection, my lord.
But the epic and also part of learn it for the response. Number one. This application, the application is part by the applicant for recording permission to intake. Senapur director of some director as contact number 1.
My lord, here I want to implement page 3, my lord. Respondent number 2, Sri Narayan Court. Secretary.
Narayan Court, Secretary to the Government of Department of the contempt is civil number 431 of 2020. Controller submits that in the contempt petition number 431 of 2022, Mr. Narayan Kaur was not treated Beside the content case number. So the requirement of employee therefore as the concept not number two and therefore they tested to develop Mr. Bora current the concept success here of accordingly take up to the love. Then was secretary to the department that's not up the contempt it's still number 430.
My lord,
With IAS. So and pick up the order passing IAS. So local learning of the five. Amended was the content is and the one
my lord, here, my lord, I may be, notice, my lord, I may be allowed to have those because it is 2022 matter.
you file the amended was the
Amendment.
thereafter pass the order in the main not in the I.
Obligation.
Well, please, Lordship. Lordship, only today we have received the affidavit in opposition filed by respondent number 3.
Now,
Lordship, kindly allow us little more time to bring throughout it to file the reply of the same.
your name is
A. Jubaria, on behalf of Arcidas.
Ace.
A. Jubaria,
Learned also we have
Arcidas.
Subsistence. That morning, we received the copy of the additional affidavit of both filed by the sorry, filed by the respondent number. And it is for and that's for after a week.
Lordship.
Her to find her response. They got not
May I please, Lordship? Kindly pass over the better for today, as Learned Counsel is going for his daughter's school for some urgency.
her miss
As Dihingia.
S
Dihingia.
S D.
On behalf of our.
3 and 4.
And so we have
5 and 1 and 2.
one
1 and 2.
one and is the by therefore therefore sir, we have 1 and the third and the concept is third
P. Fukon. R. Fukon. Sorry.
or left that for premises part. That's very weak.
Post.
After a week,
Not
there is a connected of this.
22.
And in this matter, Director Secondary Education has written to the Director Elementary Education on 9/9/2025 as reminder, minor. And before that, on 16/8/2025 and 21/5/2025 has already written the letter. But no response is coming yet. This is my instruction.
It's coming from which department?
Director of Elementary Education. There are some queries is there. in the secondary departments that here is stated, it is stated here. I have honor to inform you that you were requested to furnish a detailed report in WPC number so and so along with justification regarding the entitlement of the incremental benefit along with pending arrear, if any, in respect of petitioners. This office letters referred above. However, the report is yet to be received. You are therefore once again requested kindly to provide detailed report in WPC so and so along with justification regarding the entitlement of the increment benefit and pending arrear, if any, in respect of the petitioner. Right.
You passed on appearance before you. Elementary and second so much.
Department is not a party.
My lord,
Director elementary education.
No.
is a party.
Here director elementary education,
Education, no, not a part.
not the party.
Not a party.
Anybody appearing for elementary education?
Elementary party.
Party, no.
Hello.
The Pego, can you obtain correct on respect of the file number?
Hello.
What is the file number, Mr. Sarma?
File number here not mentioned, but letter number is mentioned here. 3 letters are already delivered to them.
The Pego, you obtain correct on
Hello.
about the status of this letter. The furnish a copy.
Yes.
Or Sarma learning complete product.
ঠিক আছে,
The issue of the response. Part. Sarma has produced a letter dated 9/8/2025, written by the director, secretary addressing the director. That provide detailed report double part
File to
and pending area planning. At the earliest, enable the director to take further necessary. And Mr. Torma further submit that the order submitted state here that the director right as a party is paid for it. However, Sir D. Pegu are expecting of the department who is present in the court. They obtain information regarding the present status of the letter. E61014 PM 70 the letter dated 1014 B from 64 dated 25/2020. The reference for on next. This is the letter. Thank you.
19.
The Sarma that furnish a copy of the letter dated 9/8/2025. And this is also reply. Subject. Letter produced. Annex are white. And shall be tagged with the report.
May I please, your lordship, my lord?
Lordship, in this matter, we were supposed to file our affidavit. We have filed our affidavit yesterday, my lord. The lordship checks the last order. Most probably, my lord, it has not come on record, my lord. So, my lord, matter may come up immediately after the vacation, my lord.
No, my lord, I have a my lord, submission before your lordship, my lord. Regarding the my lord mandatory criteria that a person's name has to be there in the Dias code of
pertaining to the year 2009 and 10, my lord. That is a mandatory criteria for provincialization of service. And regarding that aspect, my lord, I have received the copy of, my lord, the affidavit in opposition filed by the director, my lord. The director is absolutely silent, my lord. Nothing has been stated. Only said that, my lord, as per the, my lord, proposal sent by the district level scrutiny committee, my lord, the post of the service of the respondent number 6 was provincialized, my lord. And regarding that, my lord, Dias code, my lord, the director is absolutely silent. Nothing has been stated. My lord.
Well, let that come on record, my lord. Let
Lord,
the
she will kindly
affidavit come on
post it on
record.
Monday, my lord. Next Monday, my lord.
There are already a lot of matters.
Then on Wednesday, my lord, I will leave it to Lordship, my lord. Kindly, Lordship will kindly bear with me. 19. Filed.
Or sir, haven't learned it for the
B Raman, person number 6.
We don't learn it. Upset. Five. Epidemic yesterday. Saying not platform. According. Taking of the substance apart from the party. It is provided. Right. Taking the matter. Taking the epidemic.
My lord.
Yes, the last occasion, the pending council secondary education took time for filing affidavit, madam. Lordship may kindly peruse order dated 1925. Is they were given the last chance, but till date they have not filed it, madam.
My lord, regarding
And
that,
it
I have
was-
one instruction here, my lord.
Petitioner is going to be retired in the my lord in this month, 30th September. She will retire in 30th September 25, my lord. So my lord, matter is urgency is there to
My
dispose the
lord,
matter.
her case was not recommended by the district scrutiny committee.
That's why my life before this honorable court. Although my name was forwarded for provincial of my service, but no post of music teacher was allotted, my lord. Although there is provision in the act, my lord. So let them file the affidavit, my lord.
You file your affidavit.
Yes. And moreover, my lord,
That is
Uh,
not a contract case.
yes, we will file our affidavit.
Then why contempt case has been mentioned in the letter?
Probably mistakenly, my lord, it is mentioned as Montague. There is no contempt cases pending in the name of Madhumita Devi, my lord.
Then pardon, sir.
Yes, nothing.
Yes, pardon. Then use of Sir, Nath has pointed out that by order dated 19/2025, last in order to the respondent authorities to file their affidavit. But they also the respondent authorities have failed to file their affidavit. Instead, Mrs. Norma has published a letter before this court. Dated 7/7/2024. Addressed by the direct, addressed to the senior standing counsel by the director secretary. Stating that the provincialization of service of the petitioner particular in anybody high school, the district of Lukri cannot be considered under second case of the Assam education for provincialization of services of research and care training. Like, so formal submits that he may be granted some time to file affidavit in opposition by bringing record the court permission. It is accordingly allowed based on matter on
No, my lord, because my lord, she will retire immediately, my lord, on this month. So next week, my lord, and
I will be not here, my lord, from 11 to 15, my lord. So, my lord, next week,
17 maybe.
17 September. Yes, my lord.
after
My lord, moreover, she has no qualification also, my lord. As per
That is-
Assam
that is-
Secondary Education,
you file your affidavit.
yes,
bring record.
this 10 days may be granted, my lord.
Since, my lord, since 2023, 24 September.
The letter produced the court of markets and
Plus.
Well, this is pension matter. And they wanted to recover something from me. The Honorable Supreme Court said that no, such kind of deduction is not allowed when you have taken the service of a person.
Where is that order?
Supreme Court's order.
My lord, in this matter, today affidavit will file.
There.
Yes, my lord. During the course of the day, our affidavit will file here in this matter.
My lord, they have received the notice on 20th May 2024, more than 1 year. And it is a pension matter. Lordship
Today we are going to file our
Lordship know
affidavit.
that pension matter should be disposed of at the earliest. Because after retirement, a person becomes almost helpless. So improvement order, that is page 54, my lord. All communications are in my favor, but this is suddenly issued by AG. And that is duly answered also by my headmaster. That is page 55. Improvement order 54, headmaster wrote a full report 55. Sorry, principal.
What is the amount they want to recover from you?
What, they have not mentioned this. They were already, they said that the amount which has been drawn more than his right, that should be recovered. That means, my lord, first earlier I was appointed as LDA, laboratory assistant. Thereafter, I was promoted to LDA. And thereafter, my lord, I had to be promoted to the UDA. That was not done. Then I came to Honorable High Court. High Court passed order. Then I was promoted. After 15 years, again I was demoted to LDA because of the case of another person, not for my fault. Then in between these 15 years, I worked as an UDA and has drawn the salary of UDA. Now they want that in between, when he was LDA, was drawing the salary, was reverted back to LDA again. So this 15 years over payment should be deducted. That is the view of the AG. Now headmaster said, headmaster has given a reply, page 55.
Mr. Mahmood,
My lord.
let the affidavit come.
Yes.
Very short date may be fixed. It is a pension
Next
matter.
week, my lord.
What is the amount?
My lord, actually, this affidavit is filed by my lord P. Das. So she is acquainted with this, my lord, matter. And she was allotted also in this matter, my lord. So, my lord, and she informed me that we are going to file affidavit today. So Next week maybe. In the meantime, affidavit will come out.
You see, you have an office memorandum.
Yes.
So based on the decision of the Supreme Court in the Rafik Masjid case. So why the state memorandum was not followed by your department?
Well, in this matter, I have not go through this. I have not gone through this matter, my lord.
Who is appearing for AG? You are. Whether you are aware of the office memorandum issued by the Gupta Assam? Are you aware of the decision of Supreme Court in the Rafik Masjid case? No. Then let your senior account officer remain present in the court on next day.
Office memorandum is there.
Sir Mahmood guarded of the Philippines. Standing down. In secondary depart and is
on behalf of the
guarded of the Philippines. Sir, RK Talukdar. RK Talukdar. Where is Mr. Talukdar?
He has personal duties, so he left the court.
But I have noticed that you were appearing on his behalf on several occasions.
So he left the first half. He left the first half.
Ask him to remain present on next day. Mr. Thorna submits that respondent authority while their activity during the goods of the and after a week. Accordingly, it is provided that excess based on order. Then, Mr. There is one office memorandum issued by the Gupta Assam.
It is reflected in the Supreme Court's order.
Yes.
Yes, I have brought those citations here.
You bring on record the state office memorandum by filing an additional affidavit. Thereafter, we'll see why they are not implementing their own OM. Let's the matter after a week.
Is that make a little bit pension matter? It is some priority should be there.
Take it from him.
Office memorandum dated. Lordship, here on behalf of respondent number 5, Lordship. So, Lordship, 2 weeks time may be allowed for filing affidavit.
Who is the respondent number 5?
The present in-charge principal, Lordship.
Lord, he was one of the assistant professor, my lord, of the college, and now he has been given the charge of in-charge principal.
Okay. For rest of the respondent?
And that the state respondents are also required to file their affidavit. The matter is pending and they have taken time for several occasions, my lord. But because their affidavit would also be necessary, my lord.
Yes, we will file, Lordship. 1 and 2, Lordship.
Or Mr. A.L.
A.L.
And Mr. Provincial for respondent number 1 and 2. Then Mr.
P. Boregi, respondent number 4.
P.
Oh, sorry, 5.
For
5.
5. 5. For 5. Mr. Boregi submits that he may be granted 10 days time to file the affidavit. Mr. Provincial I think we granted time to file affidavit. There is accordingly allowed that is the method immediately after reopening of the meeting. And in the event of failing to file affidavit in by the appointments of respondents by court to guidance for the petition on the basis of material supplies of data.
Ablash.
May it please your lordship. Lordship, kindly have a look on the last order, 19 August 25.
Short while ago,
My lord, before my submission, learned friend taking his submission, I have some submission. Order may be, last order may be carried, my lord. Already, my lord, it is recorded, my lord. Instruction has already been received. And shortfall time for 2 weeks, my lord. But till date, my lord, I have not received any affidavit. Regarding, my lord, state has already filed affidavit, my lord. Already stand is very much clear. And my lord, I am taking only 2 minutes, only, my lord. If lordship permits me. Admittedly, my lord, this thing.
No. Yeah.
A short while ago, signed affidavit has been received by my friend, Mr. A. Fukon Mal. But tomorrow morning he will file because after 3 Mal, there is not possible to file any affidavit in the office. Short while ago, he has received.
Furnish a copy of the data.
My lord,
You have furnished a copy of the to Mr.
my lord, we are preparing, my lord. If possible, otherwise tomorrow morning, we'll definitely provide them.
Then, my lord,
Already we have received a signed
next week,
copy.
my lord, that may be fixed, my lord. Yeah.
The data. Sir. A border. Elementary education department.
I am for the respondent number 7.
What is your name?
K. I. Mozumdar Maza.
Yeah, sir.
And
I am preparing for the.
This is not yet come.
Yes, my lord. I file IA for repeating as a party respondent, my lord. Respondent number K as number. IA is pending from my lord 16/6/25, my lord.
Is
We'll see on like that.
I am the head doctor, my lord, of the school.
That
Why, my lord, I am a necessary party, my lord.
the border. That the affidavit is ready and by morning the thing is by
It's tomorrow.
then if guys go the next set up next week.
That may be fixed, my lord. Yes, kindly will take date.
They say will fix the date.
Date. My lord, date may be, major, the vacation is coming, so I am praying for only date, my lord. Otherwise, this matter will be not come before vacation. So my under humble submission, date may be fixed, my lord. Prior to that, I'm praying 24 minutes.
You say fixing a date is the function of the race.
Yes, my lord. Can it be on 22nd, my lord? 24th, my lord, and 24th. 24th, my lord. Yep. Yes.
my lord, in item number 28, my lord, there is an interim order, my lord. That may be continued.
Item number 28.
28. I am for the petitioner, my lord, from that.
Okay. Interim order passed. Item number 28.
Obliged.
Number 48.
Yeah.
May it please your lordship. Your lordship, in this matter, an advertisement was issued in the year 2024, 27/11/2024, lordship. Lordship, and I being eligible for the same, I applied. And thereafter, lordship, the 6 months have passed, but still then they have not started the selection process, lordship. And as such,
As per last order, Mother, I was asked to take instruction, Mother. What is the latest status, Mother? As per the instruction, Mother, may I hand it over? Well, that writ petition, which has been mentioned in the instruction, that has been withdrawn now, my lord. So they will continue the process soon, my lord, as per the instruction. That writ petition has been withdrawn on 20th of August 2025.
On 28th,
August 20/08, 2025. Few days back.
that your grievance is addressed.
Yes, Lordship. Your Lordship can kindly make an observation to rescue sometime steady process. Lord.
Who?
The process might be started at the earliest, Lordship.
So we may dispose of this petition.
Yes, Lord.
Yes, ma'am.
Pardon, sir? Your time, please.
If I may, Lordship, your Lordship can kindly keep the matter pending, Lordship.
Pending.
Yes, Lordship. Senior counsel may come and kindly assist us for Lordship.
Who is your senior counsel?
Senior counsel, Mr. B.D. Das, Lordship. For the time being, Lordship.
He is not present today.
Lordship, he is engaged in another matter as we speak, Lordship.
No, you see, your defense is that the process has not been taken to the logical conclusion.
Yes, I understand, Lordship.
And because of this inspection, from the inspection, it appears that because of pendency of one rate petition, number 393 of 2025, the process could not be completed. And it appears that the rate petition was withdrawn on 28/8/2025. Now they will take the process to the logical.
Yes, ma'am.
Where is your grievance? Your prayer is to issue direction to complete the process.
Yes, Lordship.
They have undertaken to complete the process. You ask Mr. Das to remain present today?
Lord, yes, Lordship. Lordship.
Lordship, may I pay fix tomorrow because I have already fixed some more cases there. I might not be available here.
This case is not important.
No, my lord. As for I have already, my lord, fixed some cases already. Those were called for, my lord. That's right. Or my presence may be excused otherwise. I have already placed the instruction, whatever I have received, my lord. They want to finish it, my lord, to a logical conclusion.
Then Mr. Das come under the.
My lord. My lord.
Highly obliged, Lordship.
We will take it out after half an hour.
My lord.
If possible, take it.
My lord.
Item 32 for orders.
Lordship, in this case, as per instruction from the judicial department, Lordship, today they have sent the file to the education department, Lordship, with their views, Lordship.
What is the way?
That they have not disclosed to me, Lordship. Yes, Lordship. So next step, Lordship, education department has.
No, next week, my lord.
Next week.
Next week. Next Wednesday.
Part the enrollment, but at the end, or what? And also part DD for the part. Yes, 4 months something there. That's for inspection. The file has already returned. by the legal department with their opinion. And this is a convenience of the matter listed on next Wednesday. Was in a reference is put about the student status, the file bearing number E69886. Accordingly, it is provided that that's a matter of Wednesday.
Lordship, remaining part, remaining part. Oh.
Lordship, this matter has been wrongly shown as quarter Lordship. This appeal has already been admitted and entry has been called for. Lordship. On 6/8, it was for further hearing, then the appeal was admitted on 7/8.
Only caveat not discharge. Caveat petition not discharge, that is why.
Caveat is fine.
We appear by filing caveat.
Away.
Caveat is there, I think. Caveat has to be discharged.
Caveat is sir.
Not discharge, that is right.
No, there is order.
Discharge. Then my,
Appeal already admitted. Lordship.
we appear by filing caveat.
You are appearing for the respondent.
But what happened in the meantime, file has been taken away from me, my lord.
Yeah.
That may be recorded. I have also give the NOC.
But sir, Gogoi learned at the day of it for the respondent. The respondent have already taken away the file from as such, sir. Amen. Substance may be deleted from the there is according to the law.
Let it be there now. Notice may be issued to them. Because I think they engage another council or not.
So that's okay. But your name will be deleted.
Deleted, but let they come engage, then my them delete.
The very basis selection of the response. This doctor.
Part may be removed, Lordship, because this matter has already been admitted and
Like
LTA has been called for.
Your lordship already heard the matter at length.
So the related of letter for part.
Always. Wait, please, my lord. My lord, actually, the mother of the deceased government servant, my lord, is before your lordship.
Orders no has.
And what happened, my lord?
Huh?
Actually, the department giving 10,000 rupees per month, my lord. And also 1 lakh rupees has been paid. Now, your lordship, the inspector of schools, my lord, this treasury officer, my lord, director of treasury, issued a letter, my lord.
Proceedings complete नहीं.
Director of Accounts and Treasuries, my lord, issued a letter dated
Next.
April 2024, 9/4/2024. So, my lord, here,
So all the responses are in this part.
here your lordship would be pleased to see, given a chart, the entitlement of the petitioner.
That letter I have given.
This matter is listed under the cause
Orders.
whether all the parties entered affidavit.
Yes, my lord. All are. My lord, there was one, that Dosti service has been completed, so all got service. My lord.
7.
7 is a Dosti service, by way of Dosti service.
That's the set.
Your lordship, just I am referring to a letter, that document, my lord.
Proceedings may completed, your lordship. It may come up on an admission hearing.
No, my lord, only thing is this, my lord, petitioner is 97 years old.
That's all right. We'll
Tomorrow or day after tomorrow, she may die. Now, your lordship will consider what submission has been made by my learned friend, my lord. Your lordship, with this letter, my lord, letter dated 9/4/2024, annexed with the annexed a chart, my lord, showing the entitlement. I'm showing, my lord.
say,
My lord,
let the matter come under admission column.
my lord. Obligation. A short bit may be given before vacation month.
Or
Service is complete, my lord.
number
I'm appearing for 1 and 4.
1 and 4. And Mr. Sarma for
5.
number
5. Count again.
and you 6.
Finance is there.
Or for 6.
3. 3.
Subject that livings have already been service and livings have already been yes. According to provided so admission hearing to vacation.
Hello.
Deeply obliged. Farhana.
Met with the losses. Losses here, yeah, I pray for 1 week, 10 days time losses. On the last occasion, my learned colleague, Mr. B. Kaushik has already submitted that the joint committee has taken a
Excused, my lord, as a pension matter, my lord, I am 97 years old already. So, my lord, a date may be fixed before vacation.
It was a joint committee. Here, Lordship, joint committee has already taken a decision that minutes are being prepared now. Once it is signed, then further course of action we will take, Lordship. So,
Committee has taken a
decision, Lordship. That minutes has also been prepared. Now the signing,
allowed up there.
Lordship.
Reject or allowed up there.
Something positive will come out on record. I am not in a position to say. Something positive will come out, Lordship. Lordship may fix after.
Same prayer, my lord, was given
Because
earlier occasion, my lord.
I admit-
Several times, some 7 times time was given, my lord. Kindly see my earlier order, my lord. I have no. Kindly see. 18/11, 1 week, 19/3, 1 week, 5/5, 2 weeks, 23, 1 week, 18/6, 1 week, 6/8, 1 week, 27, 2 weeks, my lord. Same prayer, my lord, same prayer.
Now, Lordship, telephonic.
Just instruction, they are asked to bring the instruction, my lord. They're ignoring the honorable court, my lord.
See, the submission advanced by you today.
Lordship, the same submission was.
Mr. Kaushik on 27/8.
Lordship, that I am told telephonically today, I am told that one of the member who from the finance department is perhaps not available. As a result, that minus could not be signed. So once that is signed, Lordship, then further.
When that member of the finance
Therefore, Lordship, I prefer 1 week time, maximum 10 days time, Lordship. Perhaps by that time we will have some concrete instruction in the matter. 10 days time before vacation, your Lordship.
pay some cost,
Lordship.
have to pay some cost. Granted that
Lordship, 7 days time, Lordship, this time. 7 next week, Lordship.
Just see the earlier orders. I have nothing to say.
Lordship may fix on 17th, Lordship. By the time we will have a instruction.
So from think you who have taken several dates. Since 18/11/2024.
Yes, my lord.
Already 8 months, 9
No.
months.
No, thereafter subsequent development has taken place now that matter went to the joint committee. Now joint committee has taken, they held a meeting and they taken a decision. Up to that level, that subsequent development has taken place. Now the only thing is that minutes has to be signed thereafter. Lordship. Lordship may fix on 17th, Lordship. We will have
17.
17th.
Or- it's not part- part- matter was to enable obtain the here is allowed. This is the matter 7. Statement of right to obtain the comply with the order of this court. The court will consider directing the contempt for the present.
Can it be part of, my lord? Can it be part of?
This is the part.
Obliged.
Yeah, please, Your Lordship. This contempt application is direct against Your Lordship non-compliance of the order dated 21/6/2024 at page 10, Your Lordship. Your Lordship will find, Your Lordship, there is a specific direction, Your Lordship, to appoint the petitioner, Your Lordship, as headmistress, Your Lordship. Page 11, Your Lordship. I have 1 month of service left, Your Lordship. Now. For 1 year, they kept there, in spite of there being a specific directions, they kept the matter pending, Your Lordship. Now at this stage, Your Lordship, after the filing an affidavit, they have taken stand that my age is, Your Lordship, beyond 55 years, Your Lordship. So I could not be appointed, Your Lordship. That's the stand they have taken in their affidavit, Your Lordship. But Your Lordship, they have not gone for either appeal or review of this particular order, Your Lordship. This order stands as it is, Your Lordship.
When the order was passed,
Your Lordship, order was passed on 21/6/2024. Your Lordship will kindly come to page 10.
21
6/2024, more than 1 year, Your Lordship.
on that day when the order was passed,
Lordship.
what was your age?
My age was, Your Lordship, when more than 50, around 57 years. On that day also,
What
Your
is the requirement?
requirement, they say, Your Lordship, that since it is, Your Lordship, that 55 years should be the minimum, maximum age, Your Lordship, for appointment of principal, Your Lordship. 57 years, Your Lordship.
And on that day, 21/6/2024, your age was 57 years.
57 years, and Your Lordship will kindly note, Your Lordship, it was appointment was for headmistress, Your Lordship. For headmistress, Your Lordship, there is no such requirement. They now say, Your Lordship, in the meanwhile, this has been upgraded to higher secondary, and therefore 50, the age bar will come. But interestingly, Your Lordship, the presently a person is holding the charge of headmaster, Your Lordship, not as a principal, Your Lordship. All these are to, Your Lordship, just to frustrate the order of this honorable court. These pleas are being taken, Your Lordship. In fact, Your Lordship, had it been a case, Your Lordship, I am not eligible, they should have filed a review, Your Lordship. That has also not been done, Your Lordship. This order is still holding the field, Your Lordship. Specific direction, Your Lordship will kindly see, page 11. The Director, Secondary Education Department, Assam, now shall allow the petitioner herein to function as the headmistress of the said school till the post is so filled up on regular basis in terms of provision of Assam Secondary Education Provincialization. And now, your lordship, presently one person is holding the post of in-charge headmaster, your lordship, not as a principal. Now, when my turn comes, your lordship, they are saying that since I am above 57 years, therefore I will not be allowed to, cannot be accommodated. Deliberately, your lordship,
No, Mr.
lordship,
Thakur,
lordship.
can you produce an relating the age of the petitioner so that on 21/6/2024,
Lordship.
she has not crossed, she or he has not crossed the 57.
That, your lordship, I will have to take instruction.
And where it is provided that if a person or person is above 57 years, then
Your lordship, rule 12 of rules of Assam Secondary Education Provincialized School Rules 2018. The age of the candidate must not be more than 57 years as on the 1st January of the year of recruitment. Rule 12 4, Rule 12 5, your lordship. They have, your lordship, they have not allowed me to hold the in-charge principal on the ground that B.Ed certificate is not, your lordship. I have obtained B.Ed without, your lordship, permission, your lordship. Now, relying on an earlier judgment, this honorable court hold that cannot be a ground to reject my candidature, your lordship, and directed them to fill it. They keep the matter pending for 1 year, your lordship, more than 1 year, your lordship. Today we are in the month of September, your lordship. It was passed in, your lordship, this 2024 June, your lordship. Then when we filed contempt, your lordship, after few days they hold a hearing, your lordship, and in the hearing, after hearing, now they have come up with this plea that in the affidavit, your lordship. Ultimately, your lordship, this or
You produce the document, we will see on next day.
lordship may take it up on your lordship next week, your lordship. I can produce
When?
any that, your lordship, on Friday, your lordship, next Friday.
Or Mr. Bordakur, for the petition. For the complaint. There's a later matter next Friday.
Yours.
So as to enable Mr. Bordakur to produce the birth certificate or any other certificate in respect of age of the petition. On next day. Next day.
Obliged.
Deeply agree. Okay.
Your lordship may direct the publication of the results within a stipulated time. Otherwise, it will be making, will be making the writ petition and coming back here again. They will have to publish the, because normally, my lord, it is done, as your lordship knows, as per rule 25 of the service rules, it is normally taken up the vacancies of the year 2019. So they are to take up the matter within, before 1 year of the starting of the vacancy. Your lordship is well aware of, rule 12. Okay. Rule 12(5). So 2019 vacancies, my lord, they have advertised on 27/11/24. Till date, they are sitting over them.
No.
After filing of the petition, they have taken interview. Interview has been taken now. They have to declare the results.
Today, he has produced some instruction.
Yes.
As per that instruction, one writ petition was pending before this court. For which
Another,
they
issue, I don't know.
with the matter.
There was no
The
stay order.
writ petition was withdrawn. Now they will take the process to the logical.
Yeah, within a stipulated time, that's what I'm saying. If it is, if they do it within a
Yes,
stipulated.
Mr.
Hello,
One month.
Hello, regarding that particular stipulated time, I have not been instructed anything, my lord, because they said that, my lord, after since the petition has been withdrawn, they are very soon, they are going to complete the process.
No, that will be, let him take the instruction, how long they will take. Every
That
moment, my
is-
lord,
that's-
line by line, they are taking, my lord.
My lord, it was-
They, earlier they took time for filing affidavit. Let him
Let us
take.
speak, so 1 month. Within a
Your
period of
lordship
1
will
month, you
direct.
complete the process.
My lord,
There is no bar now. Hard, Sir, he did us, our next new council, Sir,
jail authority.
our next council for the petitioner.
Trustee, may I pray for 2 months, my lord? Because there will be puja vacation and all these things, my lord.
Interview process is completed, my lord. They have to just adopt the marks and declare the result. If they bring something.
Why 2 months?
Interview held on 1/7/25.
It's not that, my lord, they are sitting, my lord. 1/7/25 interview held, my lord, because of the pendency of the petition only. It is not that they were sitting, my lord. 1/7/25 interview held because of pendency of the petition. And that was only recently withdrawn, my lord.
So evidence or an senior counsel assisted by Mr. Johnson and also heard Mr. R. Kusi, for the respondent in NC Hill Autonomous Township.
My lord, I am for respondent number 2 and 3, my lord.
Number 2 and 3.
I am for 1.
Mr.
Peter.
Sharma for respondent number 1. And this petition under Article 226 of the Constitution of India, that's rightful is with direction to the respondent authorities to complete the selection process for 2 numbers of vacant post of principal in higher secondary school in the provincialization in the district of Dimahasa. As per advertisement dated 27/11/2024 within a stipulated period of time. Mr. R. Kosik, Current Standing Council for the respondent number 2 and 3 today produced one written instruction issued by the Inspector of School Dimahasa dated 6/9/2025 and submits that the process could not be taken to the logical conclusion on account of pendency of one state petition being WPC number A9 of 2025 filed by one Nelima Mazumdar. And the said petition has been withdrawn on 28/8/2025 and now the respondent authorities will complete the selection process. Since the authorities, respondent authorities have decided to complete the selection process, this court is inclined to dispose of this writ petition by directing the respondent number 2 and 3 to complete the entire process within a period of 6 weeks from today.
Maybe
1.5
less, my
months.
lord. I pray for 2 months, my lord.
Okay.
2 months.
As per provision of law. They should not bring any other elements.
Within a period of 2 months from
As
from
per
the
provision
date
of law, your lordship.
from the date of receipt of certified copy of this order in accordance with law. The petitioner shall obtain a certified copy of this order. That's the same for the respondent number 20 of 1 week from today.
Deeply.
Please, your lordship. Lord, in the last occasion, the respondent number 3 and 4 was supposed to file counter affidavit.
Yes, Madam, you are for?
Lordship, I'm for the KAAC, Lordship. It's one number 3 and 4, Lordship.
Respondent number TN4. You have filed your affidavit.
No, Lordship, but another show post notice was issued to the petitioner on 29/8 of 2025.
What is your prayer here?
My lord, was the imprint order 26/8/2025.
Suspension order.
Yes, ma'am.
It was passed on 3/7/2023.
Yes, ma'am.
And
My lord,
thereafter,
about
it
the,
has been reviewed.
my lord.
Thereafter, it has been reviewed.
Yes, Lordship.
Yes, ma'am.
When?
Lordship, the last page, 37, 5/1 of 2024.
Page number 20.
37. Lordship.
37. My lord, regarding the so-called notice, my lord, it was issued by the additional.
But the order of this court.
Yes, ma'am. Reinstated, yes, my lord.
Oh, this as per page number 35, successful order has been withdrawn. You are reinstated in service.
Yes, my lord. My lord, but so-called notice issued on this 28, no?
29.
29 8 2025 issued by the additional director KAC. But my lord, he is not the appointing authority, my lord. He is not the appointing authority because the petitioner is the state combined employee. But the notice was issued by the additional director KAC.
He is not
not
the appointing.
Yes, my lord. He cannot.
Madam, you file your affidavit.
But
When?
3 weeks time, Lordship.
How many weeks you have already? Hard sir?
Arbedora.
Arbedora, correct. And also hard is
V. Shohei, Lordship.
V?
V. Shohei.
Hard
On behalf of Mr. J. Chutia, Lordship.
everything on the up. That's yes. So there was the direction of this court dated of in the order dated 5. no evidence, no counter affidavit has been filed. Said it was so as for later. One proof of notice issued to the petitioner. By the additional director education IT, Caribbean Autonomous District. But in order to resolve the dispute, in order to get the dispute based on this petition, affidavit of the respondent number 4 found to be necessary, and accordingly it is provided that the affidavit, counter affidavit shall be filed in a period of 2 weeks from today. In the event of failing to file the affidavit on next day, the court will proceed to hear and dispose of the petition without the affidavit of number TN4. Please, sir.
May I please, Your Lord? This is again a contempt application, Your Lordship, against non-compliance of order dated 6/9/2024. Your Lordship, order starts from page 15, Your Lordship. And relevant direction is page 32 and 33, Your Lord. The selection was, Your Lordship, directed to be completed, Your Lordship, within 3 months from the date of receipt of certified copy, Your Lordship. Page 33, Your Lordship, may kindly see. Direction number 9. Now, after filing of the contempt application, Your Lordship, after filing of the contempt application, Your Lordship, school selection committee was constituted and Your Lordship, interview was conducted. But the outcome was sent to the Your Lordship director, and director is now sitting over the matter, Your Lordship. They have, Your Lordship, why they have not passed any order, Your Lordship, that has not been disclosed by them, Your Lordship.
My lord, I am appearing on behalf of SMT 64 sole respondent, my lord. Here I have one instruction, and as per that instruction, my lord, the director has sought for detailed reports from the IS Nalbari and Assam State School Education Board regarding that matter, my lord. Regarding this matter, my lord.
That report, Your Lordship, there is no requirement, but that report has also been submitted, Your Lordship, to my knowledge, Your Lordship. And in the meanwhile, a review application is filed by the private respondent, Your Lordship. That has been, notice has been issued, Your Lordship, but no interim order was there, is there, Your Lordship.
But it is listed on 18/9/2025.
Prayer was for?
I have, Your Lordship, in the writ petition, I have challenged the appointment of respondent number 6, selection and appointment, Your Lordship. That was set aside by the Honorable Court, Your Lordship. And after that, Your Lordship, after Your Lordship making certain observations regarding the marks to be awarded, Your Lordship, this Honorable Court directed the selection be concluded within period of 3 months from the date of receipt of certified copy, Your Lordship. Your Lordship will, entire direction, Your Lordship will find at page 32, para 47 onwards. All aspects has been dealt with by the Honorable Court, Your Lordship.
Order was passed on.
It was passed on, your lordship, 6/9/2024, your lordship. 6/9/2020,
1 year reduction.
lordship. And I have submitted
Limit for compliance of the order was 3 months.
3 months. And your lordship, I have submitted the copy on 16/9.
Steps just taken by the director, written this letter to the IS inspector, Nalbari and the Assam State Board for detailed report. So sometime may be granted.
Your lordship, selection was conducted, your lordship, that was forwarded. Thereafter, why detailed report is required, your lordship, that probably, your lordship.
And here it is written that a speaking order was issued from the GB branch of this directorate by order number so and so dated the 23/5/2025. However, Sri Jayanta Kumar Borman was reverted back to the post of graduate teachers at Belsor SS School, Nalbari, and the SSB branch of this directorate was directed to initiate the necessary process to carry out the review selection amongst the candidates also participating in pursuance to the advertisement issued in the month of December 2018 for the post of principal of Belsor Higher Secondary School as directed by this honorable court. Accordingly, the SSB branch of this directorate requested the concerned inspector of school education Nalbari to submit the original proposal for selection of regular principal Belsor SS School, district Nalbari, filed office letter number so and so dated 13/6/2025 and dated letter number so and so dated 16/6/2025 for taking necessary action. Subsequently, the inspector of school and this Nalbari submitted the panel list afresh now for selection of regular principal of Belsor SS School as per honorable court order dated 6/9/2024 passed in so and so and so and so filed by the Gangadhar Burman by this letter number so and so dated 2/7/2025. On receipt of the allegation from the Jayanta Kumar Burman, this director returned back the original proposal for selection of regular principal of Belsor SS School along with the complaint petition submitted by the Jayanta Kumar Burman to the inspector of school and this is for reassessment of marking pattern as per government guidelines dated 26/12/2018 and requested to resubmit the review proposal after necessary examination of the complaint petition by office letter number so and so dated 25/7.
Which one you will comply with? The order of this court or the pair made in the complaint?
Order of the my lord, some complaint was there, so that my lord, this is stable.
Some way or other, your lordship, they want to frustrate the orders of this honorable court. Your lordship has seen it, your lordship. In every case, your lordship.
Well, sometime may be granted so that fresh instruction may be.
Okay, if based on cost, we'll grant you that.
And then next week, my lord, SMT60 will be there, my lord.
This is the model apparently adopted by all of you. In one matter, one complaint. On the
No, due to my lord, his personal difficulties, he has to leave, my lord. So he told me and this instruction given to me, my lord.
You produce the compliance order before this court or next? Hard, sir. Or the court learned from. Then also hard. You, Sorma, learned counsel acted on behalf of Mr. accept this. Mr. Sorma has got his letter. disqualify the contempt of offset. I think that state has been taken that the inspector not valid. And the Assam State Statistical Board Division 1 submit detailed report and on receipt of which and on receipt of the said report further the take taken to comply with the order of this court. So Portakur learned for the petitioner submits that the direction was issued by this court by order dated 6/9/2024. And more than 1 year elapsed. And on this or that pretext, the contemptor has not been complied with the order of the court and tried to circumvent the order of this court. And taking note of the submission of Mr. Portakur, the petition prepared for the contemptor, it is provided that on yes, on 17th September, director, the contemptor shall produce compliance order of this court, compliance order before this court at 2 p.m.
After vacation, my lord. After
Pardon?
vacation. After vacation, my lord.
After vacation. Okay. 14th of October. 14th of else, the court will consider directing the director to personally present before this court on a subsequent date to be fixed by this court. The matter produced before the court today that we marked as necessary. So, take with it.
Deeply obliged.
Yes, please, your lordship. Lordship, as per the law Zima report, service has been completed. A date may kindly be fixed for admission hearing.
Pardon, sir?
J. Saikya.
Sir Soikia submits that as per order of the law department dated 25 service as the matter may be listed for admission hearing. Accordingly, it's provided that this is a list of it for admission.
Nice.
May I please beg your lordship? My lord, the basic grievance in the writ petition is a challenge to a transfer order, my lord. My lord,
I
admittedly,
is for what purpose?
my lord, IA is for, my lord, for the stay of the subsequent, my lord, so cause a proceeding which they have initiated, my lord, for the purpose of not joining me in my transferred school, my lord. That is the issue, my lord. What has happened, my lord, in the meantime, subsequent development one after another, my lord. Now my salary has also been stopped, my lord. There is an order that I should not be paid the salary. My lord, what has happened, my lord, from school A to school B, I was transferred, my lord. In the school B, I initially joined, and thereafter I again came back, my lord. Although there is no any verbal, no any written order allowing me to resume my duties in my parent school, my lord. But my lord, during this course, the department also did not take up any action, my lord. Was smoothly I was discharging my duty in the school A. Now, my lord, subsequently, when I came before my lordship, my lord, by challenging the transfer order after my joining, then, my lord, these issues are coming up, my lord, one after another. That as I have not joined and doing discharging my duties from school B. So, therefore, my lord, a departmental, not as a departmental, my lord, a so cause at page 19, my lord, annexed 3 had been issued to me, my lord, which I had also responded to also, my lord.
So, my lord, the, although, my lord, IA had been filed,
First you tell me what is your prayer in this I and what order is to be passed here.
my lord, the IA is that this, my lord, the prayer which we have made, my lord, that the, as this, my lord, to, not to proceed the departmental proceeding, my lord, challenging that to responded to so-called notice to issue to the applicant, my lord, during the pendency of the writ petition, as the my lordship is already in the session of the matter, my lord, there are judgment, my lord, passed by this honorable court, my lord. When the court is in session of a matter, my lord, honorable court, then the respondents may not act upon, my lord, the issue or taken up the issue, my lord, subsequently by issuing a press order, my lord, which they have done here, my lord. My lord, may I pray the entire writ petition is required to be disposed of, my lord. I have to sum up the issues, my lord, whether the transfer order is maintainable or not. My lord can decide the issue, my lord, and
This matter is listed under the column order.
order, my lord, because of the IA, my lord. Because of the IA.
Then let us fix the matter immediately after the open.
My lord can, I will be so pleased, my lord, only my limited prayer, my lord, as I am doing, discharging my duties from school A, my salary, my lord, may not be, my lord, this is
That
the,
order is not part of the record.
that is correct, my lord, that is correct.
So why his salary is stopped?
Lordship, may can you see the scenario? He is transferred from school A to school B. He goes to the school B, he joins, he comes back and discharges his duty in school A. Then Lordship, he is not doing his duty in school B, Lordship. How that arrangement has been made? That came to light and accordingly the so-cause was issued, Lordship.
But for that you cannot stop his salary.
Lordship, without discharging his place of service, Lordship.
He has been rendering his services.
No, Lordship, he is rendering in the school from which he was originally transferred.
No, for that.
How there is no stay from this honorable court, though he, after joining, he has approached this honorable court, nor there is any kept in abeyance by the authority. It's a misconduct committed by the petitioner, Lordship.
Okay, he has committed misconduct. What is the remedy?
Lordship,
His salary.
Lordship, he has to reply the if authority stoppage his salary, Lordship, if he is doing in duty in the school to which he is transferred.
He has been, this is misconduct. What is the remedy?
Lordship, he is misconduct, he is not rendering his duty in school B, where he is posted. Lordship, DP will be initiated.
DP.
Departmental proceeding will be.
You have stopped his salary?
That Lordship, if he can produce the letter, Lordship, he has not produced any letter, Lordship. No. There has been stoppage of the salary. Lord, we have served a copy to my Lordship. That Lordship, I have no knowledge that there has been stoppage of salary. My learned friend has stopped my salary, my lord. Not my learned friend's client, my lord. He has to bring that on record, Lordship. If there is a.
Bring it, but you instruct him to release his salary. Otherwise, he has to face the consequence.
But Lordship, he is not rendering his duty in the place of posting. Then Lordship may give that direction, Lordship. If he is.
Under what authority he has stopped the salary?
Lordship, how he can make an internal arrangement and render his duty in school from which he was transferred.
Mr. Sharma, you have to act in accordance with rule. Which rule provides for stopping his salary?
Lordship, let him bring that on record. I will take the instruction, Lordship.
He has produced one letter today.
That he has not, neither any document has been given to me to get the instruction from the client.
So, yeah,
My lord.
you submit a copy to him.
My lord.
Then he will release his salary.
My lord.
Next step, we will take action other.
My lord. Copy এটা দাদা দিতে কপি দুই তিনটা বনাই রাখিব নোৱাৰো
Here, we have learned something for the picture. Mr. B. Chaudhary for the respondent number.
My lord. For three, Lordship, I agree.
Number 3, as for
So respondent number 1 to 4 and 5, Lordship.
1, 2, 4, and 5. Mr. Huya submits that the petitioner has also prepared an introductory application, and the same is also pending for consideration of this court. However, Mr. Huya submits that the introductory application as well as the written may be considered and disposed of on a date fixed by this court. And during the course of deliberation, Mr. Huya has also produced one letter issued by the District Elementary Education Officer of Dai, dated 26 May 2025, directing the Block Elementary Education Officer Division Dai to hold up the salary of the petitioner. In view of the submission of Mr. Huya, learned counsel for the petitioner, Mrs. Hoduri, learned counsel, is directed to obtain instruction under which provision of law the District Elementary Officer Dai directed to set up the salary of the petitioner to the Block Elementary Education Officer. The rest is the matter on the 23rd. Mr. Bhuya shall furnish a copy of the
My
letter to
lord.
Mr. Choduri during the course of the day. And the letter produced to the court shall be marked as sanitary and shall be tagged with the record.
Lordship, since I have not gone through the letter, Lordship, if it is issued by the elementary department, then my friend will have to take the instruction because I'm appearing for the SSA.
Oblige, madam, highly oblige. May I please? This is the first time to appear before this honorable court will say, I'm appearing for the response number 4 here. So you have, possibly allow some time to file a reply.
Lordship, in this case, what has happened? Like my learned friend Lordship, the petitioners before your Lordship, they are the law graduate Lordship from Koregon Law College. They applied for enrollment from the Bar Council of Assam. And there is some dispute between the college and the Bar Council of India, for which the enrollment certificate has not yet been issued. But in the meantime, the principal of the college has written a letter to the Bar Council of India that they had paid all the fees. Kindly peruse that letter, Lordship. And
It is the,
let me,
it is the Bar Council of India, it is, they have been carried.
Lordship, one thing is that if some of the petitioners 1 to 11, they cleared the AIB exam, Lordship, and their AIB tenure of 6 months will be expired on 21st September, Lordship. Page 88 is the clause, Lordship. So I may be with the student may be protected, otherwise there, if the enrollment will be delayed, and then AIB period will be over on 21st 3, Lordship. And if they will not expire, 20 September, Lordship. This month, Lordship.
Next week we will discuss better.
Oh, yes, yes.
Lordship,
Because
let it be.
Bar Council of India is a authority to issue to participant, they have been saved. We are follow the rules and regulation of the Bar Council of India. If they have said because they have not given any affiliation in a session of 2021. So on this period, they have stopped their affiliation.
Kindly, for a moment, Lordship, 103 page.
No, today we will not hear it.
Lordship, then Lordship, a short time maybe because 21st is the last day for this. I pray, Lordship, next week any day subject to convenience of this honorable court.
Your name, please?
H. Chetty, Lordship, for response number 4. Response number 4.
And it may come on top of the day, otherwise they will.
Six. Number 6. Anybody? Service completed.
Lordship, we have taken the steps as well as personally served to the copy to the Bar Council of India, respondent number 2, 3. But There was an office note, Lordship. We had served the copy, Lordship, personally by registered post as well as the Honorable Court also, Lordship. For this Honorable Court. Lordship, I pray, Lordship, for the exigency of the protection of that, Lordship, 21st September, Lordship, is the last day. I pray next week, Lordship. Otherwise, the future of these 11 students, those who have passed out, Lordship, the AIB exam, Lordship, and if the enrollment, I hope and trust that the Bar Council of India, maybe you and my learned friend may intimate the things.
We have nothing to do.
No.
This is bad idea.
No. You have also, I have in my additional affidavit, Lordship, there took a resolution. Bar Council of Assam.
We have sent it.
Resolution.
It
The
is their
council
prerogative.
considered.
They have taken a step.
I'm being my Lordship.
Mazumdar,
Lordship, please. Yes.
you served the notice upon respondent number 2 and 3 by Dastipur.
Dusty. Lordship is from Delhi. Lordship is the student.
Pardon?
There, we already served it by registered post, Lordship, speed post. And we have a copy of that also, Lordship. We have a copy of that. Dusty service, Lordship, is a Delhi, Lordship.
Here there is office.
No.
Bar Council.
My learned friend,
Bar
I will
Council.
serve the copy. May I pray,
Bar Council. India is there. Chairman.
I pray, Lordship, the Bar Council, we have taken the steps by registered post, speed post also. I have a copy of that, Lordship. No. And
Then you obtain the report from the fiscal department that they have.
Lordship, it may be fixed on Wednesday, Lordship. I'll produce the same, Lordship. Because I have a copy of all these, Lordship. Registered post.
Have you gone through the office note?
Lordship, I have checked it, Lordship.
Checked it.
Lordship. I have gone
As
through
per
it.
this office note, they have not issued the notice.
By the office.
Yeah.
But I personally served the copy. I have a copy of that, Lordship.
They have not issued the notice as because you have taken step only in respect of 2 and 3.
They are
Not in
the
respect of other.
others, Lordship, will serve the copies of Lordship. I have a notice of that.
Office note said that as per direct message code, you have to take step upon all the.
Oh, he took it. There is a notice also, Lordship. I have also served the copy by registered post as well also. And served the copies. Accordingly, my learned friend has already appeared. And also notice is there, Lordship.
Is it provided in the High Court rule?
No. I'm only for exigency of the service, Lordship. I have served the copy because main respondent 2 and 3, Lordship. If necessary, Lordship, through Dosti service, Lordship, I'll take my step to my learned friends. They can send it. Or Lordship, my
authority.
Website, Lordship, their website is there. I will serve the copy, Lordship. To the Bar Council of India, Lordship.
Office note dated 8/9/2025 indicates that so steps has been taken in respect of respondent number 20. The same not be as there was direct court author number 24.
We serve the copy, Lordship.
In view of above, it is provided that Mr. Mazumdar shall take testing of respondent number 20.
By
registered
website.
with AD and also by usual process.
Lordship.
The service is also permitted. When after effecting service by the stable, the petitioner shall file an affidavit report.
Lordship, on Wednesday, Lordship. Because 21st is the last day. With all respect, Lordship, I am praying. Because urgency.
Unless the notice is served.
Lordship, by their website, I will send to by register the service, everything, Lordship. Wednesday or Thursday, Lordship. Next Friday, any day, Lordship. Next week, Lordship.
Friday, next Friday.
March oblige, Lordship.